Thank you, Yasmin. Good morning to all our board members, our members of the public, and all our Department of Justice staff that is assisting us this morning. My name is Angela Sierra. I'm an attorney with the California Department of Justice, and I am Attorney General Rob Bonta's designee on our RIPA board. And I, along with Andrea Guerrero, am a co-chair of our RIPA board. As you all know, this morning we have convened a meeting focused on discussing the topic of racial profiling by state and local law enforcement in California in light of federal immigration enforcement that has been happening in our state. We have convened 2 panels today, and as Yasmin noted, there'll be an opportunity both for board discussion after each panel, as well as after each panel, an opportunity for public comment. Before we begin, would like everybody to introduce themselves. I'll turn it over in a moment. And lastly, we'll be adding that I will be facilitating today's meeting in light of the fact that our co-chair, Andrea Guerrero, will be serving as a panelist today for us in her capacity as Executive Director of Equity Alliance of San Diego County. So, but with that, I'm going to turn it over to Andrea for her introduction, and then she'll be turning it over to our other board members. Thank you.
Good morning, everyone. I'm Andrea Guerrero, the Executive Director of Alliance San Diego. And shall I pass it, Angela?
Yes, please.
Amina, I will pass it to you.
Good morning, everyone. My name is Amina Kazi. I'm a civil rights attorney based in Orange County, focusing on police accountability work. And I'm an appointee of Attorney General Rob Bonta, and I will pass it to John Dobart.
Good morning, John Dobart, Vice President of Policy and Programs at Catalyst California, and an appointee of Speaker Emeritus Anthony Rendon. I will pass it to Board Member Diallo.
The board members, not the general
Thank
public.
you.
They for fucking effort.
Good morning. My name is Sule Diallo. I'm a supervisor at the Riverside County Public Defender's Office and a designee of the California Public Defenders Association. With that, I will turn over to Board Member Smith.
Good morning, everybody. Chauncey Smith, appointee of Attorney General Rob Bonta, with Catalyst, California. I will pass it to Board Member Green.
Good morning, everyone. Captain Darren Green, California Highway Patrol, designee of Commissioner Sean DeRee. And I will pass it to, I'm having trouble seeing everyone. Anyone who has not gone yet, that's who I'll pass it to.
I can jump in. Bill Armeline, NAACP of San Jose, Silicon Valley, also San Jose State University, sociology, Senate reappointee. I want to say thank you to Andrea and all of our folks today. They're going to lend us their expertise. I really appreciate their time. Same, I'll pass it to anyone who hasn't gone yet. So it's a little tough to get the video to pop up for everybody here right now.
Let's see, I think maybe Manju. I see you.
Yes. Good morning, everyone. Manju Kulkarni, Executive Director of AAPI Equity Alliance and co-founder of Stop AAPI Hate, and designee of Speaker Emeritus Anthony Rendon.
Thank you. Let's see, is there any other board members that we have not noted, have not introduced themselves yet?
I'll jump in. This is Board Member Lily Kajavi. I hope you can hear me. I'm a professor at Loyola Marymount University in Los Angeles in the Department of Mathematics, Statistics, and Data Science, and appointee of the Attorney General's Office. And I'll just add, I'm using Teams on the web today, and I noticed if you click on video, at least on this display, if you click on video, prioritize video is an option, and doing that allowed me to see not all the board members, but it shifted which screens were there. So I think I can see most of you. I don't know if that tip is helpful. And thank you so much for gathering us today at this really critical topic. Thank you.
You.
I'm sorry, can I jump in real quick to add to that? This is Board Member Delbar. If you click on view and click and check prioritize video, then everyone who's on video will pop up.
Great, thank you. Huh. Okay, let's see. I think that is, let's see, did we get, we have all our board members? I'm trying to, I think there may be,
I haven't
Any
gone
other-
yet. Can I jump in, Angela?
yes, please, that'd be great.
Hello, everybody. Good morning. Ronaldo Villeda, appointed by the Attorney General. Glad to be here.
Perfect, thank you. Okay, I believe that are all our board members, unless I hear otherwise. Wonderful. Well, thank you all for being here. We all really appreciate it. And, you know, as has been noted during these introductions, you know, this is a really critical discussion we're going to be having today. This meeting today was convened in response to the many comments we received from our board members with respect to this topic, and we wanted to address that. And so we are very thankful for the board members and for the presenters today. Again, both co-chair Andrea Guerrero and will be presenting alongside Chief Manuel Rodriguez. They will be beginning in a bit. And we will also then be having a presentation from the Department of Justice, both with one of our supervising deputy attorney generals, and as well as the Attorney General Rob Bonta will be presenting to our board today. So we are very thankful for everybody's time and look forward to a very constructive and informative meeting today. So with that, I'm going to turn it over to our first panel, Andrea Guerrero and Chief Rodriguez. Thank you.
Great. Thank you so much, Angela. And I really appreciate the opportunity to present to the board on this topic of immigration and how California can respond to bias and abuse of power by federal immigration agents. I am joined today by Chief Manuel Rodriguez. He's a retired chief, and I'm going to ask him to just introduce himself before we get started.
So my name is Manuel Rodriguez. I'm retired from law enforcement after 33 years. I served with the San Diego Police Department and National City Police Department. So I have experience in both large agencies and obviously smaller ones. I think a lot of what I bring to the table is my years of working in this area. In 1991, I helped craft the undocumented persons policy for San Diego PD, which was actually the first comprehensive change, I think, that many agencies covered after that. And so I think that today really is about us collaborating together to understand the framework of what is going on and how we can make things better for all Californians. Because I think the way I look at it, it's important for us to all find some common ground here. And, you know, law enforcement, I think in California, I know that we've always strived for best practices. And certainly, even though there's always been more work to do, and there always will be. So thank you for having me today.
All right, thank you so much. So with that, I'm going to share a screen. Great, okay. So in the context of what's been happening across California, the RIPA board has asked for a presentation around immigration and California's potential response to any abuse of power by federal immigration agents. That includes bias, which is the charge of this board around racial identity profiling, as well as the actions that follow from it, including the abuse of power. So that's what we'll be talking about today. And to level set, I'm going to share some information about immigrants in California, so we all have the same foundation to speak from. In California, there are over 10 million immigrants who call the state home. 1 in every 4 of us is an immigrant, myself included. Half of all California children have an immigrant parent. And immigrants in California come from all over the world. They are neighbors, our friends, our co-workers, and our family. So what is the status of immigrants in California? Well, more than half are U.S. citizens, more than a quarter are legal residents, and less than a fifth are undocumented. They amount to 1.8 million, and they are very vulnerable right now. And of course, many California families have people with mixed status. Most undocumented Californians have lived here for more than a decade. Immigrants contribute to California in a number of ways. Over half of all California workers are immigrants or children of immigrants. Undocumented workers in particular contributed $8.5 billion in state and local taxes in 2022. And of course, immigrants contribute to innovation, culture, and community in the state. And they do this despite the United States having a broken immigration system. Immigration pathways are limited. You should know that the immigration system has not been updated for 35 years. There are not enough visas for family members, skilled workers, or refugees. And for the 1.8 million undocumented Californians, there are no lines to stand in right now. They live in limbo, raising their families and contributing to our economy. It's also worth noting that while the immigration system is limited for most, it is not limited for millionaires who get their own visa with a fast path to citizenship. So there's a degree of inequity in our immigration system as it stands. Instead of fixing a broken immigration system, the federal government has focused on harsh enforcement. We see that here in California. And that enforcement solves nothing, but it does separate families, disrupt the workforce, and traumatize our community. So what is going on in California? Well, ICE has arrested over 12,000 Californians from January to July of this year. And right now, ICE is arresting over 100 Californians a day. And they are arresting immigrants, people who look like immigrants, citizens, lawful residents, and bystanders. The harsh enforcement that is going on right now in California affects us all. So those arrests, they lead to detention, and in some cases they lead to deportation. The Californians who have been deported so far this year are majority male. In many instances, they are the primary income earners in their families, and so their arrest, detention, and deportation creates tremendous struggle for the families that are left behind. They vary in age. Deportees have ranged from newly born to 87 years old. And they come from a wide range of origin, over 125 different countries. So what can, what can California do right now? Well, it's important to understand that the U.S. Constitution has something called the Supremacy Clause, which states that the federal government...
1 second.
If you could go on mute, if you're a member of the public, that would be very helpful. The federal government has authority over federal matters, including immigration. And so California cannot control what federal agents do, but they can determine what state and the local officials can or cannot do. And California is leading the nation in creating the safeguards to minimize the harm caused by harsh enforcement to families in the state. We have some cutting edge laws here in California, including the California Values Act, which the Attorney General's office is going to say more about later, but in short, it restricts state and local officers from engaging in immigration enforcement. We also have the California Racial and Identity Profiling Act that prohibits profiling by state and local officers. And we have the Truth and Trust Acts, which provide due process to immigrants in state and local custody and restrict their transfer to ICE without a warrant. Now, while these laws are directed at state and local officials, because that's what we can do in California, because of the Supremacy Clause, that's the limit of what we can do. It's important for California to model the treatment of immigrants, to model the protection of constitutional rights in the state for others to follow. And then I did want to mention briefly, we do have new laws that have just been passed that prohibit state and local officials from consenting to ICE searches in non-public spaces like at schools and health clinics without a judicial warrant. And so in the long term, what California models is going to be really important to create the conditions for the federal government to do the same, as well as other states. And now we're going to turn to the meat of the presentation. I'm going to turn it over to Chief Rodriguez to talk about the rights at risk and the duty to intervene to protect those rights. And Chief, if you just want to give me a finger when you're ready, that sounds bad, but if you want, yeah, a thumbs up when you're ready for me to switch screens, I can do that.
I am ready.
Okay. Take it away.
Okay. So first, let me start off by saying, you know, I think from a law enforcement perspective, it's not about, you know, not having a border patrol or not having an immigration enforcement. To me, it's always about how it's done. And I think that's a key focus of what today should be. It's how things are done, because that's really what we're talking about. Folks that are violating the very Constitution they're supposed to support. And so I just want to make that clear. I mean, I think, you know, they have a job to do. Law enforcement has a job to do in general, but it's not about the job you're doing, but rather how you're doing it. And I think that's a key point for me. So freedom from discrimination, the U.S. Constitution, the Fifth Amendment guarantees equal protection, prohibiting discrimination by federal agents, including based enforcement such as profiling people based solely on their race and identity. And again, even though that is the U.S. Constitution, it's always about how it's interpreted. There is no federal law like the California Racial and Identity Profiling Act, which prohibits profiling by state and local officers. At this point, it appears that, you know, DHS may be engaging in racial profiling despite the constitutional prohibitions that exist on that. Freedom from search and seizure. The Fourth Amendment prohibits search and seizure unless agents have a warrant signed by a judge based on probable cause. Now, why we keep emphasizing judge is sometimes you'll run into some of the immigration folks and they have a warrant. But if it's not signed by a judge, then it really doesn't have the enforcement power behind it. So I think that's an important distinction. Federal law, US 8 USC 1357 gives Department of Homeland Security agents sweeping warrantless authorities that pose risk to everyone's civil liberties. And that's the key. Okay, it's not necessarily, you know, a brown person. It's anybody that they feel is in the U.S. Illegally. And so they are able to interrogate anybody about their right to remain in the U.S., arrest individuals that agents believe are violating immigration law, enter private property, not dwellings, within 25 miles of borders, board and search any car, train, plane, or vessel within 100 miles of the borders. And then the term, boundaries include coastal and borders and international airports. So that falls within the majority of the United States because most states and cities have international airports, at least the major ones do. Many of us are along the coast, of course. So it's a large portion of the United States. Freedom from excessive force. The U.S. Constitution, the Fourth Amendment, prohibits unreasonable use of force. To be reasonable, force must be authorized for a legitimate purpose and be necessarily and proportional, right? And while there is no real standard, the treaties signed and ratified under Article 6 of the Constitution is a good reference point for that. Federal law, there is no federal law on the use of force. Although the Department of Homeland Security policy prohibits deadly force unless necessary and requires safe tactics that minimize risk of injury. And so again, there is a policy. I think, whether they're following or not is maybe subject to interpretation, and there may be some issues there. So duty of law enforcement to intervene. But what is the duty to intervene? And again, a lot of times when we look at this is a very, I think, important question. It's a difficult question, but I think it's a very important question because when we're talking about, the California officers have a duty to intervene. And so when we look at that, we say, well, how do they have this duty to intervene? And it always happens when there is an apparent or imminent excessive force, and officers have a professional, legal, and moral duty to act. And so what are we basing this on? Well, professional duty. There's no question that Law Enforcement Code of Ethics, our Oath of Honor, and national practices, which is often called best practices, 21st century policing. These are the things that I think provide for us to ensure that we're doing a professional duty. So under legal and ethical duty, the California Government Code 7286, which really mandates that law enforcement agencies in California have policies that de-escalate, that minimize force, those kinds of things. And then universal responsibility. These things applies to agencies across agencies and ranks. So regardless of your rank and regardless of your agency, these things apply to you.
And Chief, if I could
Sure.
draw out a little bit more information, because this is really important. The professional duty documents, the Code of Ethics and Oath of Honor that every law enforcement agent or officer takes, they have specific language around duty to intervene. Is that correct?
That's correct. I know that it's always, most people haven't read those, but us and law enforcement have. And there is no question, that officers have a duty to protect. And that's really the fundamental duty, is to protect people from harm, protect people's rights. And so, and it's taken a while, but I think that, 21st century policing really has brought that to light. And it's a conversation we've had for a while now.
Right. Thank you so much. And then in terms of California Government Code 7286 that you referred to, that is also specific language about duty to intervene in instances of excessive force. And we're going to get into how to intervene, right? But that is explicitly, as is the Code of Ethics and Oath of Honor. Those all have explicit language about duty to intervene, correct?
Absolutely. And the part of that is, it's interesting to me because that has always been the standard when you talk about Code of Ethics and those kinds of things. But California has specifically passed a law to ensure that that is clear. And that's what 7286 really does.
Thank you so much. And then can you say a little bit more about applies across agencies and ranks? Because I think there's a question about whether junior officers can can intervene against senior officers, whether one agency can intervene against another agency. Can you say a little bit more about that universal responsibility?
Absolutely. So I think what happens is, and we often forget, within law enforcement agencies, they use a paramilitary structure, you know, and so if somebody of a higher rank is doing something that is unethical or immoral, then officers obviously have a hesitation to take action. And this particular universal responsibility of, your professional duty applies regardless of what your rank is. So if an officer sees, unlikely, but a captain beating up a suspect, the officer has the duty to intervene, even though they are just a regular police officer. And so it doesn't matter what rank it is. It doesn't matter, where you are on the chain of command, because that's what we call it. It's important that everybody understand that this applies to, all agencies and regardless of people's ranks.
I appreciate that.
Did I clarify that? I hope.
Yeah, and we might get questions about that, but we'll turn to the how to intervene, which is really coming out of California Government Code 7286, but is also reflected in these other documents and policies listed here.
Perfect. So again, the idea becomes, how can officers intervene? And I think a lot of times, we think of officers intervening as a physical thing. We know from de-escalation that, that's not always true. A lot of times intervention can be as simple as, hey, I have my camera on, you need to make sure that, you're doing what you're supposed to be doing, those kinds of things. So, and really what we're talking about is when you respond, you try to de-escalate, right? We're trying to use crisis intervention techniques. So if an officer happens across a very tense situation, even especially physically, then they need to respond by trying to de-escalate the situation. And again, that could be as simple as, hey, just so you know, I have my camera on, because that will help people to get back to their normal sense of thinking. Record, certainly, making sure that if there is an incident, that everything's documented thoroughly, body cams are uploaded, reports are filed, and then obviously witness statements taken. So that's an important aspect. And that's just a record. And then of course, filing the report and identifying which agencies were present. And then of course, the incident of what, the details of what happened. Arrest. So this is very unlikely in my mind. Okay, but I don't think it's beyond the realm when somebody is witnessing somebody getting beaten. And we'll talk a little few of the felony that officers may witness. And so arrest when there are clearly Fourth Amendment violations like excessive force. And one of the challenges, of course, in law enforcement is, it's unfortunate, but it's a violent type of situations that often happen. I always go back to the person that I said, sir, you're under arrest, but I don't want to be arrested, and the reality of it was that hopefully that doesn't turn physical, but if it does, it never looks good. And so, but based on officers' experience, and like I said, unlikely to happen. I think that there may be, if there are, clear violations. And then the last one is to investigate where serious injury or death occur, and there needs to be an independent investigation. Questions on that?
Well, Chief, if we could draw this out a little bit more, because you have more experience than most because you're in the border region, right? So in the border region, we have seen instances of pretty egregious use of force, excessive force by Border Patrol agents, but also ICE agents. And okay, and members of the public, if you could stay on mute, please, while we're presenting. Yes, if everyone could be on mute while we're presenting, that would be great. And so in the border, we have in instances of excessive force, Fourth Amendment violations by DHS agencies, and it is the practice down here that local law enforcement agents where the incident occurred would investigate. That could be San Diego Police Department, that could be Chula Vista, or your own former agency, National City. So I think for folks who are in other parts of the state, they perhaps have never contemplated this. Can you say a little bit more about that?
Sure. So anytime there's an incident near the border that involves, well, actually anytime, depending on the jurisdiction, that, you know, ICE or U.S. Border Patrol are involved in any kind of incident where there is a serious injury or death, usually it'll be the because it's a configuration here in the Southern California where the border is, the international border, is a little weird because you hit the city of San Diego when you first cross the border, and then as you move north, you'll hit a bunch of different cities, and then you'll be back to the city of San Diego. That's why Andrea said, well, the city of Chula Vista can also be involved. But let's say at a shooting, the San Diego Police Department would send investigators to do the investigation to ensure that, you know, the use of force was appropriate. And if it's not, then, you know, through their investigation, turn that over usually to the DA's office for prosecution. Because again, you know, state can only use state laws, you know, and feds use federal laws. It's kind of like a two-rail system, right? And so that's essentially what would happen. And when we talk about this, this is an important example to keep in mind because that's really what we're talking about. You know, using the state laws when people have violated the state penal code.
Okay, so much, yes. All right.
So let's see, role of prosecutors. Okay. State and local prosecutors have an important role to play in considering criminal charges of federal agents who violate the rights of Californians. And of course, again, as I just said, one of the important aspects of this is really state and local prosecutors can only charge for violations of state law within the California Penal Code. Federal immunity applies to agents if they acted within the scope of their duty. So again, you know, there is qualified immunity under federal law as there is for state law. Use of powers of under 8 USC 1357 has to align with the Fourth Amendment. And prosecutors must assess a clear constitutional violation. So this is very important. You know, you have to tie it to a violation of Fourth Amendment. And so that's important. And then one of the things that probably make sure that the case doesn't move to federal court, because more than likely there would be no violation under federal court. But again, you know, in an era where we're experimenting with new laws and difficult changes in how the challenges to government. And what I mean by that is, you know, when was the last time a nonprofit had to sue the federal government for not getting their grants? I mean, you know, that to me, those are the kind of things that's like, okay, that I know of, that's never happened. But you know, it's what's happening now. So again, I think that if you have to build a solid case and make sure that you know, if you want that to move forward, that it stays within the state court systems.
And if we could tease this out a little bit. Okay, so here's what I understand. So for prosecutors to bring charges, they would have to identify that the agents violated state law. And because federal agents have federal immunity, that the prosecutors would have to demonstrate that the agents were acting outside of the lawful scope of their duties. And the lawful scope of their duties begins with the restrictions under the Fourth Amendment, right? And so it wouldn't be, for example, lawful scope of duty would not, for example, be what a president put into a text. It would be what the Constitution allows for and what federal law allows for, as long as it's in line with the Constitution. So at the end of the day, it's the constitutional violation that would dictate whether federal agents were acting outside of the scope of the duty, which would then allow prosecutors to press for charges, right?
Right. Yes, and that's what we want to focus on here. You know, it would be the Constitution, and it would be the laws that apply in that instance. It wouldn't be, you know, some tweet or something like that, oh, you know, I'm authorizing this. That's not going to do it.
That's not going to do it, right? And you cited here 8 U.S.C. 1357, and that's what you mentioned earlier. Those are the quote unquote warrantless powers that DHS asserts it when it's engaged in immigration enforcement. But that must be read with anything that they do under those quote unquote warrantless powers must align with the Fourth Amendment to be lawful. Is that correct?
That's correct. And so I think, you know, those are the legal powers given to the immigration officers. And you know, you have to put this into context. These are extremely broad powers. And so I think sometimes people forget that. You know, warrantless powers are not to be taken lightly. And it's more than most law enforcement agents that I know of. Actually, all law enforcement agencies that I know have while they're on duty. So I think it's important to understand that this is a very, you know, gives the immigration Department of Homeland Security great powers in enforcement that other law enforcement agencies throughout the country don't have.
And that they have to be balanced against the Fourth Amendment rights and protections that we have in the Bill of Rights. So, okay, and then on this last point, because I think folks who don't operate in the criminal justice system may not understand this last point. So I wanted to tease this out a little bit. So as I understand it, if, you know, let's say a police department does an investigation of an excessive force committed by a federal agent, they would then send that to prosecutors. That could include the district attorney, that could include the California Attorney General as well. And those prosecutors would then potentially bring charges in state court. The federal agents could request that the case be removed to federal court, which is a common practice, but the state prosecutors can ask that it not be removed, and that might be even more important right now, given the context and the harm that would be caused by removing it to federal court, given the lack of accountability that we're seeing right now. Is that right?
Absolutely. I think that, you know, if you have a solid case, you need to keep it in state courts because federal court is going to be a more difficult challenge to deal with. And at one point, they may just be kicked out. So there's a lot of work done, you know, because usually if it's going to be prosecuted, there has to be a lot of documentation at the front end. There has to be a lot of work on the prosecution end. And then finally, when it gets presented before a court. And so I think that, you know, you have to make sure that, you know, you try not to have that happen to you.
Right. So because potentially, you know, a district attorney or the attorney general would attempt to bring charges in state court. If the case was removed to federal court, then the prosecution would be taken over by the U.S. Attorney General or Department of Justice, and they could then, once having removed it, ask for the case to be dismissed. So in that way, there's no accountability, and that's the real danger here, right? And that's the important role for local and state prosecutors to fight for these cases of state violations to be heard in state court.
Absolutely.
Yeah. Okay. Well, let's move on. Next.
Okay. So, one of the things that we wanted to put down is some of the, charges, because these are all felonies, and that's really what you want to focus on. That could be brought against, somebody that is violating people's Fourth Amendment rights. So, assault with a deadly weapon, aggravated battery, child endangerment, where they're not taking, precaution with the kids, elderly endangerment, which is basically elder abuse. And then, of course, kidnapping. And are these likely to be filed? Probably not, but they're important for officers to understand and recognize that if these things are happening before you, then you probably need to intervene somehow. And that is, de-escalating and recording and making sure that, you're following your agency's policies.
Right. And we're in, quite frankly, unprecedented times, right? And so these are tools that we have in California, that California law enforcement has to intervene if they see these things happening, to do as you suggest, and as what state law directs, which is to respond to an incident, to record the incident, to report the incident, and if there's serious injury or death, investigate the incident. And of course, arrest is always a possibility on the table, right? We recognize the unknown and the uncertainty of the moment, but we do have tools in California to protect the public.
Absolutely.
Do you want to? Mm-hmm.
So, why this matters, right? And I think from, law enforcement officers in the state of California, public safety depends on, public trust, right? One of the things that over the last, actually, almost 30 years that we've been pushing is community policing. And community policing really depends on having the public trust law enforcement. And, and that helps to lower crime in the communities, because then people are more willing to report crimes, share information, and help investigations. Now, I will tell you that from a law enforcement officer, one of the things that I think has been challenging for us is we're used to collaborating with other law enforcement agencies. I don't think that's ever been a question. We have task forces, federal task forces, state task forces. So we're always been collaborating with other law enforcement agencies. And I think that the tone sometimes from DHS, it's changed somewhat and has made it more difficult for local law enforcement to cooperate in the way that they used to. And so sometimes that's what you're really trying to balance. You need to make sure that you keep, as a law enforcement agency, the trust of the community you serve, because that's the only way you can make them safer. And that's the only way that you can have that collaborative attitude about, fighting crime in your community. And so when you add this element, that it makes it more difficult. But in the end, I think that law enforcement, local law enforcement agencies need to make sure that, they're working with their community to understand their needs, and in general, continue to build that trust, even in these particularly difficult and challenging times. So, trust depends on the legitimacy of state and local law enforcement. So I think a lot of it has to do is, through transparency. And when I first started in law enforcement, transparency wasn't even a word we used because anything that we did, nobody needed to know about. And over the decades, that has changed. I remember one of the first chiefs that tried to start transparency in the San Diego Police Department was Jerry Sanders. And it was interesting because he said, probably 60% of the stuff we can let people know about. I'm not sure why we're keeping all this information. And so that's where I saw some of the transparency in, being brought into agencies. But, a lot of what the trust depends on and making sure that, as I mentioned earlier, people's rights, constitutional rights are protected under the Bill of Rights, under the Constitution, and certainly, under the Penal Code. So one of the things is clarifying the duty of state and local enforcement to intervene. Okay. And again, I think one of the things that law enforcement agencies have been struggling recently with is the fact that, you have immigration coming out in your communities and conducting these raids. And so, that puts, if you have a large immigrant population, and even in some areas where you may not, they may create fear in those communities. So I think a big part of what today is about is really just making sure that law enforcement agencies clarify, the power for officers to intervene. And again, when we're talking about intervene, it doesn't always mean physically. It means going back to the, topics that we were talking about regarding making sure that they respond, that they de-escalate, use crisis intervention techniques, record and report and take witness statements, file their report to identify who was present, and then, of course, investigate if there's any serious injuries. The physical arrest, is something that is highly unlikely in my mind, because that would have to be fairly egregious. And again, I think that we have to make sure that law enforcement, local and state law enforcement agencies focus on the protections of people's constitutional rights. And so by having policies that, require officers to intervene, which they probably already have, honestly, it's, and remind them, that it's important to empower their officers. And of course, it applies to the prosecutors as well, that it's important to honor your oath and protect the public, regardless of who's, who may be involved. And I think that's key. So again, we're not talking about people not doing their jobs. We're talking about how people do their jobs, and they need to do it within the rule of law. And I think sometimes people forget that. And they're challenging times now, but it's important that we remember that. Community policing is, the foundation of good policing, and I think that that needs to work. All the agencies need to be reminded of that, and of course, de-escalation. If officers are involved with DHS, they need to make sure that they can de-escalate as much as possible, because that's a major challenge when emotions get high. And so that's all I have.
Okay, well, thank you so much. And I just will note, you mentioned task forces, and I wanted to make sure that the public was aware that California Values Act, which is SB 54, that the Attorney General's office is going to go more deeply into, prohibits law enforcement from engaging in immigration enforcement. There is an exception for joint task forces that are not primarily immigration focused, for other things. So just wanted to clarify that. If you keep your sound mute, that would be great. We're almost done here. But in wrapping up, I would just say that, you know, the Attorney General does have tremendous resources available on its website. I think my hope is that the takeaway today for the members of the public and for law enforcement is a deeper understanding of the duty to intervene, the rights to protect the constitutional rights that we all have here in the state of California, so that the community can feel comfortable calling law enforcement to intervene when that is necessary. There is a trust gap. I want to recognize that between law enforcement and the community, but one way to build the bridge of trust is through the protection of the constitutional rights of people in this state. When you are called to respond, whether that's by the federal agency or by members of the public, that you will understand and honor your duty to intervene to protect the public, and that the public will increase its awareness and knowledge and expectation of what law enforcement, local and state law enforcement can and will do to hold federal agencies accountable, to use the powers we do have to do that. That's it for the presentation, and we will open it up for questions. Is that right, Angela?
Yes, great. And thank you, Andrea and Chief Rodriguez, for the excellent presentation. I would like to open it up to questions for these panel members from our board. We have till about, I would say, 10:15 for a Q&A, and then we'll open it up for general board discussion regarding this panel. So if anybody would like to ask a question, if they could just raise their hand, and we'll go from there. Thank you.
Most of you are probably like me. Takes me a little while to digest what was just told, and it's like, okay, let me see how I can,
Exactly.
digest what I just heard.
Yeah. Well, I'll jump in. I have a few questions. I'll jump in with the first question. On the duty to intervene that you've both been discussing, is that something that is standard practice that is trained like at the academy and throughout, like field officer training? And is that duty to intervene trained, as far as you're aware, typically trained in terms of both what a local or state law enforcement officer may be doing in view of another local officer, as well as what a federal peace officer may be doing? Is that typically presented in that broad way?
No, normally duty to intervene, they've incorporated, I think, into the academies, police academies now. So it's part of what is there as part of the curriculum. California Post, I believe, also provided what they called officer training for that. And so the duty to intervene was not just the law that was passed, but rather includes training. The California Post Peace Officer Standards and Training mandated that officers get the training on, because it's one of the things that when you see abuse by any police officer, and I will tell you that it happens, but it's I think it's more rare than people think, but at the same time it gets a lot of attention. And so duty to intervene is, I think, part of the police academy curriculum, and also mandated by Post to provide officers. Now, federally, that there's no correlation, because obviously state doesn't have any you know, say in how federal officers get trained.
Right. And then just to follow up, your slide that, you know, recognize and outlines the different ways one can intervene, because I think often people initially think it's like physically intervening, and this respond, record, report, arrest, investigate. Is that something that's actually, you know, in the statute is pretty standard with respect to how an officer would be trained? That those are the you know, the ways that an officer can approach this?
Yeah, absolutely. I think that, you know, one of the things that has been a big training area for, at least in the last 5 years that I know of, if not longer, is the de-escalation. Actually, probably longer than that, 10, 15 years that we've talked about de-escalation. And so that is something that they do. Obviously, with the adaptation of body-worn cameras, you know, the recording part of it has also have been, you know, something that officers do on a regular basis. I will tell you, when they first started using body cameras, it was sometimes hard to get the officers to turn them on, because there is a, you know, component of that. But the reality of it is that, you know, the department established policies, and then once you establish policies, then you obviously establish the training, and then you move forward, and then usually that's not an issue. So record and, you know, eyewitness accounts, officers do that every day. And then of course they file the reports, you know. I think, and to investigate, every officer does that. So,
but this would be pretty standard training, and these are the ways, these are the tools you have as a peace officer.
That's correct, and they currently have all those tools.
Okay. And then finally, I do, because this is really a rich area for us to be thinking about. Given that California has a Values Act and limitation on what local and, you know, local law enforcement agencies, you know, and the prohibits, you know, prohibiting local law enforcement agencies to be engaging in immigration enforcement. Typically in this realm, if ICE is involved in an incident, is it more likely the case that if a local law enforcement agency is going to at all witness anything, it's going to be after the fact, because they wouldn't be part of the actual incident? Or is that really is it more nuanced than that?
I think it's a little more complicated, yes. You know, because sometimes local law enforcement will respond when ICE asks for help, you know, and sometimes people will say, well, they shouldn't respond to them. Well, no, you know, when law enforcement asks for help, law enforcement will respond to that help. And so they may get there, and there may be something going on that, you know, they find an officer or may see that, you know, that's just excessive. But many times, yeah, it will be after the fact. Yeah, you're correct in that sense. But it can happen that, you know, as officers respond to assistance for calls for help or whatever it may be, they may witness something. And again, so I think it's not always just after the fact, but it can happen. You know, and one of the other things, of course, is patrol officers. They're out in the field all the time. They may be witnessing an arrest, you know, from ICE, where they see that maybe perhaps it's, you know, out of control. So that can happen as well, just like any crime. You know, I remember when I was a patrol officer, you know, driving by and seeing somebody getting robbed, you know, and so obviously you have to intervene, and, you know, and in this particular instance, you know, the officers would probably try to help, you know, to contain the situation. So they would intercede from that perspective, at least.
Okay.
And we know, if I could just add, we know that this year local officers have been showing up for two reasons. One, they're getting a call for mutual aid from the federal agencies. So that's not a call to intervene in that's not a call to assist in the immigration enforcement. It's a call for mutual aid which has taken the form of like, we need you to do crowd control, like you're not engaging in immigration enforcement, but we need you to do that. And so that's led to a situation where officers are present, they may be witnessing things, but then I don't think it's been clear enough about what they do if they see something that's a constitutional violation. And then the other way that local officers are coming is that community members are calling. So in a call for service, something's happening, and they call them, right? So regardless of how local police are called in, whether it's mutual aid by the federal agency or call for service by the members of the public, they should, in the interest of transparency and building trust, they should clarify with the community they are not there to engage in immigration enforcement. And they should absolutely intervene in all the ways that we've been describing, in order to build trust with the community, to de-escalate, to record, report, etc. And then I think what's really important for the public to know is when officers do those things, then there's a record that is subject to the Public Records Act request that members of the public can then access. And so we have started to do that here in San Diego. If you file a federal Freedom of Information Act request to try to get information about an incident, it may take years. But here we have very robust laws around Public Records Act requests, and you will get, within 10 days, you're supposed to get a response if there is a record, if there is a report. That's why it's so important for us to clarify for law enforcement that their duties to intervene under California Penal Code 7286 are understood clearly, that the agencies who previously may not have contemplated how they apply to incidents involving federal officers now think about that question. That no one had to contemplate that before. Now we have to contemplate that.
Thank you. That's really helpful. Not seeing any hands, I'll jump in with one more question. Moving over to the topic of racial and identity profiling. With respect to, reporting and the concerns about profiling that may be being conducted by federal immigration agents. Are either of you aware of how some or any local law enforcement agencies in California are either addressing that with respect to the conduct of their own officers, or just kind of addressing that issue, given, California's, strict prohibition against it versus what, is being reported, on the ground with respect to immigration enforcement?
Are you saying, are we aware of any law enforcement agency profiling like DHS, or I'm not sure I understand the question.
My question is more to about whether local law enforcement agencies maybe are beefing up their policies or their training, or how they are bringing this to the attention of their officers, the local officers, to ensure they're not engaging in this, or just in that, how, if any way, they can address this issue on the local level.
Well, I think that the training officers have been getting regarding racial profiling through California Post has been instrumental in making sure that they're aware of that. And so I don't know of any agency that doesn't have a policy on that. But, that officers do not engage in that kind of behavior is certainly paramount to, I think, what most agencies try to interject. And, I think sometimes with this racial profiling, I think California is probably at the head of that. Because it's taken a while, but just the formation of this board, I think, speaks volumes about this issue, right? It's important enough. So I don't think that is an issue for state or local law enforcement. But how it applies to federal law enforcement, that's a difficult assessment because number one, we're not getting a lot of information from DHS. And certainly I do not think that necessarily they're getting the additional training. California peace officers are required every 2 years to have 24 hours of additional training. That's not a requirement for federal agents or DHS agents, I should say. So, and part of that whole idea of this ongoing training is the fact that officers are provided the information that's important to the community as a whole in California, because that's what, California Post does. So officers are aware of racial profiling, they're aware of the dangers of it, but how that translates into federal, that's, I think, anybody's guess.
Yeah, and I think we're in a difficult moment right now where federal leadership is, explicitly encouraging racial identity profiling, despite the constitutional prohibitions against it. There's no federal law that strengthens that prohibition, and so it's very challenging circumstance, right? The best that California can do is model efforts to combat racial identity profiling here in the state. There are other states looking to California. There are federal legislators looking to the RIPA law itself. We know we have miles to go in California. Our reports say so. Our reports tell us there is a repeated pattern of profiling. But I think what sets California apart in this board and the work that we do with members of the public and stakeholders is that we're hitting it head on and to acknowledge the profiling that's going on and try to figure out how to address it through the recommendations we make. I wish that was going on at the federal level right now. It's not, but we need to take the long view and model the world that we want to live in.
Thank you. Let's see, is there any other board members have any questions of our panelists? If any, I don't see any hands raised, but if any board member wants to jump in, please do.
I can, while you're thinking about a possible question, I'll just add, that this topic of duty to intervene is relatively new with regard to federal immigration agents. It's a conversation that is happening not only here in California, but in other states as well. In many ways, California is better positioned to test out that duty to intervene and to educate the stakeholders around it. We have a law that 7286 that explicitly provides for a duty to intervene, and you attach that to the oath of office and to the professional ethics code, and you have a very clear path for what officers should do here in California. So I think it's really important for everyone to really understand what that duty is and understand that this is the path that we can use to protect members of the public and, quite frankly, protect our constitutional rights. Because if we don't exercise them and protect them, they will erode.
Well, Andrea, just to follow up on that, so the duty to intervene with respect to the federal officers, you're saying is that concept is relatively new. Are you aware, or Chief, either of you aware of any agencies, local law enforcement agencies that are actively grappling with that, or maybe establishing policies around that. I mean, sounds like it's a conversation that's evolving, given the times we're in. And if we were interested in down the road, talking to some potential model agencies, to the extent that you may be aware of that, would be helpful.
I'm not aware of any agency doing that. I think from at least a chief's perspective, I wouldn't probably do that, since I already have it in my policies, the duty to intervene. There might be a conversation around, with command staff regarding, hey, if your officers witness this, and, remind them of our policy, that, the duty to intervene, because the duty to intervene is really just, I think, focuses on law enforcement, when all law enforcement loses control. I guess that's the best way to describe it, and I mean, I think that all law enforcement agencies are aware of that. They have it in their policy. Like I said, it's something that has always been there, but it's not something that was emphasized. And now it's in all the policies. It's not just in the law enforcement code of ethics. It's now obviously in state law. So there's been a lot of changes over the last, 8 to 10 years to ensure that officers know about the duty to intervene. And again, how you apply it to what you're seeing is what the key is, right? And so that's where the conversation needs to happen. Because I go back to it's not that DHS officers can't arrest for immigration violation. Nobody's saying that. What we're saying is how you do it. And it needs to be within the constitutional protections and the rule of law, because I think that's what's more important here.
Yeah, and
I hope I answered your question.
Yeah, so I know of several agencies who are not developing new policies, because the laws in California is clear. We don't need to reinvent that law, right? We have that law. We have the professional code of ethics, the oath of honor. All of these things exist, right? So it's really about contemplating how this applies to federal agents, and I think because of that, there are local governance bodies like city councils, as well as working with their local police departments, trying to think about protocols that would be clear, that would be an expression of these duties. And that would go a long way to helping the community create or understand what kind of expectations they should have, and the expectations that that local law enforcement would be working to meet in the interest of accountability. I think right now the public is uncertain about what the role is of law enforcement, and there, you see headlines like, "Are they kidnappers?" Because they're seen as just standing around and creating a perimeter for immigration agents to engage in excessive force, right? And so really, and then law enforcement is like, well, I don't know what to do. And I've had several conversations with officers just in the last week, like, well, until I get direction, I don't want to touch that. That's a mess, right? Because if I engage, then I'll be seen by the community. No matter what I do, I'll be seen as being involved, which I'm not supposed to be involved. So it's that tension between you're not supposed to be involved, SB 54 California Values Act, and yet there's a duty to intervene. So I think, to the extent agencies are developing protocols around this, that is going to be helpful to all the stakeholders to understand what the expectations are. But yeah, we're in a moment that nobody really contemplated, although we do have a little bit more experience in the border region. I think Manju, now we've got questions. Good.
Yeah, great. Okay, so Manju.
Great. Apologies, I don't have the name of the case here, but Andrea, you referenced a little bit the recent, I think, U.S. Supreme Court decision and what has now become known as the Kavanaugh stop, which is to detain, according to Kavanaugh, for a short period, I put that in quotes, individuals based on race, and other what we would characterize as inappropriate reasons, such as being low income or wearing attire that suggests low income or working class. So can you say sort of more explicitly, if the Supreme Court has said it's constitutional, supposedly it is constitutional. So how that works now, and now that these Kavanaugh stops are deemed legal, what that means in this realm. And then secondly, my question is too about the fact that, even though we have the Values Act in California, my understanding is that it is quite routine for law enforcement agencies, especially in smaller jurisdictions, to cooperate with ICE, and that there are many, many examples of that, and that I believe there have been a number of reports. So I guess my question is, like, we're asking for proactive action when law enforcement agencies are not even following the law that has now been in place for a number of years.
Yeah, I can address those questions. So there is no formal Supreme Court decision yet. So there's a case out of Los Angeles about racial profiling by federal agents. This is where the federal government is asserting they should be able to racially profile, use race, accents, etc., to be able to profile to do their jobs. The case is still in the court system. There was a request for a stay to stop the federal government from engaging in this profiling while the case was going on, and the Supreme Court justices weighed in on that stay, on the stay, not on the overall case, on the stay. And that's where, Justice Sotomayor wrote a very compelling thought piece, and so did, and then Kavanaugh wrote something. And so Justice Kavanaugh said, well, they should be able to do it, and this is why, right? His reasoning was had left a lot of holes. So that wasn't a formal decision on the case. It's still being processed, and I'm certain that the attorneys in that case will directly address the threat that Kavanaugh posed by letting the stay go, right, and allowing the profiling to proceed in the course of the case. So that's a TBD situation, a to be determined situation. It is absolutely a potential threat to the work that we do at the California RIPA board. If that case was going to be decided in a way that said that interpreting the Constitution as allowing for racial profiling. But we have a long way to go in that case. The Constitution is the Constitution, and it's up to us as Californians to claim our constitutional rights. And no one can ever tell us that they don't apply. They do. Justice Kavanaugh is just one justice. So that's a fight that's ongoing. With regard to the pass-offs, police pass-offs, that's something we monitor really, really closely down here in the border region, because that's where it's most likely to happen. It's most likely to happen between an officer and a Border Patrol agent in particular. And we are monitoring for that. It is rare. It does happen. It is rare. And when it happens, we are on top of that really fast, and we are on top of it with the law enforcement agency leaders and the city leaders. We know it does continue to happen, but it's the exception, not the rule. And if anyone ever hears of it, you should let your local advocacy organizations know. And if you ever need any guidance on how to respond, you should feel free to reach out to me.
Thank you. Appreciate that, and appreciate the clarification regarding the Supreme Court decision.
We have a question from Amina Kazi.
I thought we had switched to discussion, so I have a comment that can wait till we get to that portion.
Great. Okay. Well, I think those were all the questions, and now we can move to our board discussion, which we have till, I would say, 11 a.m. So we have a good amount of time to discuss this. Again, Andrea and Chief Rodriguez, really excellent presentation and follow-up. Can't thank you enough for your time and all the information you've provided to us. Going to give us a lot to be thinking about and discussing. So thank you very much. And
thank
why don't we
you.
move to board discussion? Oh, I'm sorry. Go ahead, Chief.
No, I'm sorry.
Please go ahead.
No, I don't have anything I just want to say thank you for having me today. And, I know that this is a new area, but these are challenging times for all of us, I think, in the nation. And certainly I think California is trying to meet the challenge. So thank you.
Great. Thank you. So now we'll move to our board discussion, and let's start us off.
Board Member Sierra, could you repeat that? Sorry, I think you cut out. And actually, while
okay.
I'm speaking, can I just say thank you? I just appreciate that presentation so much, and I learned so much. So I just want to say thank you before we discuss to both of our presenters. It's profound. Thank you.
Fantastic. Okay, so if I was being cut off, I want to now move us over to our board discussion. We'll have till a little over half an hour. And I know Amina Kazi, you had raised your hand for board discussion. So why don't we start with you?
Great, thank you. And thank you again, Board Member Guerrero and Chief Rodriguez, for the very informative presentation. My thought is coming both from a couple points that were made during the presentation and also my experience. I have a lot of experience working with demonstrators on First Amendment issues. And I think where there might be some ambiguity with law enforcement about whether and how to intervene in these situations, there has been no ambiguity from community and the public on their duty to intervene and to demonstrate and vocalize how federal law enforcement or federal immigration enforcement has been really impacting their rights, has really been tearing families apart. So when we hear that law enforcement is called out to deal with these demonstrators, we have seen many examples myself in Orange County and the Los Angeles area on extreme and excessive uses of force against demonstrators and the public. It's been very ugly. It's been very traumatic, not just in these field encounters, but then also when people are taken in and booked, and what these demonstrators experience through an extended booking process, through lack of sanitation and food. It's a very traumatic. So it's re-traumatizing a community that's already being traumatized. So I don't feel that law enforcement often is kind of on the periphery. I feel that in these sorts of situations, law enforcement officers they're directly involved and have now become complicit in this enforcement of this inhumane federal immigration practices. So that's what I wanted to share. And thank you again for all the information. I don't want it to come off that it wasn't, I mean, my comment really has arrived at from all that was shared, and just thinking about who's doing what, and the public is stepping in to fill that gap that hasn't been filled.
Yeah, understood. Thank you. I'm muted. Sorry. There is a hand by, I think, of Sully Diallo.
Yes, thank you. I first like to thank Chief Rodriguez and Board Member Guerrero for a great presentation, very educational. And I couldn't help but just express my initial reaction. It's a sad day that we're here. You think about something like the duty to intervene in a normal context, maybe interagency where there's a consensus about what road behavior is between officers, and an expectation of officers in terms of observing conduct of their fellow officers, and how to deal with that situation. Never has it been contemplated that we have interagency kind of conflict on this level, to the extent where we have a federal government agency who is really antagonistic to some of the values and policies of California. And on a systemic level, we have that sort of conflict. And in that, there's so many tensions and difficulties in applying what was meant to be for a certain situation to a different situation. Now, I think it's a tool, and I think there's an expectation in terms of from the public right now that in terms of how law enforcement acts in this situation. But I think there's also a policy gap to try to resolve a lot of these tensions. First, just in terms of, let's say in a normal time, and maybe under things that we would have contemplated in years past, and not where we're here now. Maybe there could be interagency policies that would deal with some of these things, and communication between federal and state. We're not under that environment right now. So I think it's up to both local law enforcement, it's up to policymakers, it's up to even at the state legislature to try to meet this moment and addressing some of these gaps. And I think there's a community expectation of that. Because on one level we have, Chief Rodriguez mentioned this, and I've heard this echoed from members of law enforcement in terms of kind of an expectation in normal times. If a federal law enforcement agency calls for assistance, I'm outside the context of direct immigration enforcement, for example, or let's say outside of immigration in general, that an expectation that there's a cooperation between state and local, and it's important that we have that cooperation on all kinds of different levels. But we have that tension with the Values Act, number one, and especially where we have an agency that really is antagonistic and pushing that tension. So we have those three things, and then to the extent that there is a local law enforcement agency participation in terms of be it so-called crowd control, or be whatever incidents may arise from ICE intervening. Those lines are very fuzzy. They need to be, I think, addressed by policy in terms of what the people's expectations are and circumstances. Because of this natural tension, when law enforcement should respond, when they shouldn't respond, what their exact participation is. And I think coupled with also a statement of, okay, even if we are responding in some sort of backup level, with the restrictions of the Values Act, that's going to be coupled with a duty to respond. And in terms of recording, in terms of filming, in terms of reporting, in terms of some of the things that we've had to articulate to the federal officials what our response would be on a local and state level. that's not, a substitute of what would be better would be cooperation, but at least there's some guidelines for local law enforcement and to meet the needs of the public who really in a crisis moment is looking to our leaders to try to fill some of these gaps. But I don't pretend to have the answers to all of this. I mean, I see nightmare scenarios in this situation that our laws are not fully equipped to grasp with.
Yeah.
So it's all an open question. It's good to have this discussion, but there's definitely a gap that needs to be addressed in terms of policy making on this front.
Thank you. Thank you. Any other observations, comments, input from other board members?
I'd love to jump in.
Great.
While others, I hope, are gathering thoughts to share. I really resonate with what Board Member Diallo said, that even though we do have constitutional protections, we do have duty to intervene, there is that tension with SB 54, and it does lend itself to a need for further clarity, or whether that's at the agency level through protocols or at the legislative level. I share your dismay that we should have never had to be here. I will say, just from the border region, that we got here a little bit before everybody else. And I call it the borderfication of California. Because what's been happening here is now happening elsewhere. And so we do have a little bit more experience, both law enforcement and in the community. And I think as a baseline, the opportunity here for the public to understand who are immigrants in the state, what are the rules and rights that govern, and where the gaps are. The conversation that we're having now is really important. I've seen a lot of questions coming in. I haven't seen very few answers from around the country, and I think California can really provide some of those answers and model what best practices should be in this moment.
Thank you, Andrea. Let's see, we have, Chauncey Smith.
Hello?
Yes, we can hear you.
Yeah, thank you for the planning and thought that went into today's presentation. This is an extremely important issue for millions of Californians, and I'm grateful that we're having this conversation and making an effort to be responsive to what's most important to many of us, our loved ones, and people in our networks. So one thing I'd like to add to today's conversation about some of the problems that we have seen, a lot of the discussion was about immigration raids and the relationship between local law enforcement and federal agents when there's interpersonal interactions. One piece I'd like to add to the equation as a significant problem that I've seen numerous reports about in the news and through communication with partner organizations is information sharing between local law enforcement and federal agents that's used for purposes of federal agents determining where to conduct raids. So as already been mentioned, we're a sanctuary state. We have many sanctuary cities, counties throughout the state. And there's been numerous, and as Andrew explained earlier, they're not supposed to be collaborating. But there's been numerous reports from a variety of news outlets about ICE accessing local law enforcement surveillance technologies or being given access to those technologies, such as license plates readers and other things like that, in order to determine where immigrant people are at and to determine where the raids are, should occur. So this is an extremely problematic issue. I don't know exactly what the solution is aside from more accountability and efforts to prevent local law enforcement from providing that access. But based on what I've seen, this is a significant issue. And in addition to the interpersonal interactions that that Andrea and Manuel spoke about earlier, I think a key piece of the equation is the information sharing and the improper use of surveillance technologies to attack immigrant communities.
Thank you. Yes, Andrea, if you want to speak to that.
Yeah, Board Member Smith, I'm really glad you brought that up because I think that is probably one of the greater risks that we face here in California is the surveillance issue and the information sharing. And I think it's hard because we don't necessarily know it's happening and we don't have a way to see it happening as opposed to like the stops in the street and the pass off. Like we can see that happening, but the surveillance stuff is a little harder to understand. I would just say that, that's a live issue down in the San Diego region, I'm sure all over the state. And, I think we need to do everything we can to enforce SB 54. So whether it's a pass off on the highway or, an unlawful information sharing through digital means, it's going to be up to local prosecutors, and the Attorney General has been really clear about his interest in holding law enforcement agencies accountable for this sort of action. So I think we can't protect our rights unless we claim them. We can't claim them unless we know them. And so that's our work, right, is to help people understand what their rights are. And hopefully the Attorney General will say more about that coming up. But we shouldn't sit idle if we're aware of a violation of SB 54. We should pursue legal action in the court we're a big state, lots of people, over 500 agencies. Things are going to happen. It's going to be up to all of us as stakeholders to make sure that we're enforcing SB 54. And I would just put one more note in that the other vulnerability we have is around joint task forces. I recognize that there's a need for joint task forces, but within the joint task forces are exempt from SB 54, right? And so anything that's happening in a joint task force, any kind of surveillance sharing would be exempt from 54. That is a gap that's probably worth looking at more closely to address.
I just wanted to say there was an article on Friday of the Attorney General suing the city of El Cajon for sharing license plate data with the federal government and out-of-state law enforcement. So, I didn't know if you were aware of it. I just wanted, because I knew I had read it, but the memory is such a terrible thing. I thought it was Monday, and actually it was, I guess, Friday that I read that. So that is happening.
Thank you. And we'll be having a presentation, as Andrea noted, by our Department of Justice, and our Attorney General will be, in part discussing our Values Act. Let's see, do we have any other board members who would like to have observations, comments regarding these topics? I don't see any hands, but I'm just double checking. No, okay. This is, yeah, there's a lot of information for us as a board to digest, contemplate, think about. I think as many of you have noted, there are gaps, but there's tensions, there's some ambiguity. There is be a lot for us to think about and work out to see how we as a board, given, our mandate, with respect to, racial identity profiling and how this is related to that topic, to see how, we can contribute to improve things, for all of us in California. But this is, a major step in, getting this conversation more substantive, and really appreciate it. And then we're going to be having, as you all know, another board meeting next week, and these discussions, will be continuing. So, with that, let me ask our DOJ staff if we can turn now to public comment, or should we take a break from your perspective? See?
Yeah, Yasi, you're muted.
Yes.
Sorry, I'm having some audio issues today.
Okay.
Are you able to hear me?
Yes, we can.
Great. I believe we can move to public comment.
Okay.
And then I will let you know if we need to take a break afterward.
Terrific. Okay. And will you all then be able to help facilitate that? I will just open it up for public comment. And so, yeah, we have an opportunity for public comment. We ask that they be kept to 3 minutes or less. And as our practice has been, that we don't, as we're hearing the comment, what we are doing is taking it in for us to consider and then later discuss. So I'll open up geographically. I'll start with Southern California. If there is any members of the public from Southern California that would like to make a comment. And I see one hand from Omar Ariza. If you could unmute.
Hello, everybody. My name is Omar Ariza. I'm a former firefighter and also a board member of Alliance San Diego. My question is concerning police officers and the duty to act for medical purposes. So over the last couple of years, we've seen heavy interactions between, ICE agents, immigration agents, and over excessive force, but we haven't seen like medical presence at these situations that are on the spot, right? So if a person gets taken down and they're injured, are these officers immediately taking the public away without providing first, the duty to act? And when the police officers are, called on scene to, keep the scene safe, do they have a duty to act because they are EMTs, they are medically trained individuals, to say, hey, before you leave, he needs medical attention, and can interact, and prevent them from being taken away as quickly as possible? Has that notion been brought up in the past? And is there any statistics on, whether medical aid is provided on scene or post, of anything of that sort?
Okay. Thank you. Thank you for that comment and questions, and, providing us in that slightly different context and something that as a board that we can talk about and explore. Thank you. Any other public comments from Southern California? I don't see any hands.
I would like to speak, please. Thank you.
Sure. And Karen Glover. Yes.
Hi, folks.
Thank you so much for today, and I'm just going to make 3 points, some of which y'all have already been talking about, but I think it's important to reiterate. One of the things that I'm noticing here in North County, San Diego is, at least with one of our local law enforcement leaders, they're often framing local law enforcement and ICE or federal agents' interactions as keeping the peace between the community and the feds. So they're trying to frame it as kind of a equivalency, that they're protecting both sides, and indeed that there's a need to protect both sides. And I find that I understand it on some level, but it's also problematic of their framing of the issue, as opposed to, at this point in history, solidly showing their solidarity and protecting the community that they're sworn to serve. The other thing I wanted to say was, and I jotted it down in the comments, is that I think, at least from my experience with folks here locally, is that they are also concerned about jeopardizing their relationship with the federal government, that they are hesitant to do things because they have relationships, both formally and informally. And then the final thing, and I hope it's not too dramatic, but I really want to thank the RIPA board. You know, it seemed like this meeting came up rather organically out of a shared pain and suffering of what's going on in our community, and y'all took this up. And I've been, like many of you, probably doing research on what happens in rises and falls of authoritarianism. And what those studies tell us is that our security forces are key to what happens, that our security forces choose the people or they choose the state. And that's why your work and this kind of underlying thing I'm hearing today about policy, reiterating what we have in place, but also thinking of bringing up more training for them, reminding them of their responsibilities to the Constitution, even though we know that's out the door on some level in reality. But it's really going to rest on them to a great deal. So our attention to it and your important attention to it is greatly appreciated. Thank you.
Thank you, Ms. Clover. Let's see, any other comments from Southern California? Okay, why don't we move to Central California? Do we have any members of the public from Central California that would like to make a public comment? Okay, seeing no hands. How about Northern California? Do we have any members of the public from Northern California that would like to make a public comment? Okay. Seeing none, I think we will, that will be the conclusion of this first public comment period. There will be another public comment period toward the end, near the end of our meeting after our next panel presentation. So let me ask our DOJ staff if we should take a 10-minute break, or would you prefer that we begin the next panel now?
Thank you, Co-Chair Sierra. I think we should go ahead and take a 10-minute break so we can resume at 11:02 and then we can move to the next segment of the agenda.
Wonderful. Okay, so let's take a break and we will resume at 11:02. Thank you.
everyone. As it's 11:02, I'm going to ask that board members please turn on your cameras and let us know that we can reestablish quorum.
Yasmin, it's a little difficult to hear you. You were cutting out a little bit.
I apologize. Are you able to hear me now? Great.
Yes.
I just wanted to ask that board members please turn on your cameras so that we can know who has returned from the break. And once we establish quorum, we can go ahead and get started.
Wonderful. Thank you.
Okay, I see that we have 6 board members currently on camera. Have any other board members returned? If so, please do turn on your camera or let us know in the chat that you've returned so that we can go ahead and restart the meeting. Are board members Armeline, Smith, and Kulkarni with us? Okay, I believe we do have a quorum, so we can go ahead and begin the meeting. Or I'm sorry, continue the meeting with the DOJ presentation.
Wonderful. Thank you, Yasmin. And we are back now on our discussion with responses to racial and identity profiling and immigration enforcement. We are on our meeting agenda at 3 subdivision D, and we are going to have a presentation by the Department of Justice. And our first part of the presentation will be with Supervising Deputy Attorney General Joel Madero. And then a presentation, we'll be able to meet our California Attorney General, Rob Bonta. So I will turn it over to Joel to begin his presentation. And thank you so much for being here and doing this for us.
Thank you, Angela, and good morning to all board members and members of the public. I have some slides that are prepared for today's presentation. Don't know, Yasi or others, if you may be able to upload those at this moment.
I can go ahead and pull those up. Just give me a minute.
Yeah, I see the slides. Yasi, will you be able to control those for me, or should I, or can I?
I believe so. I'm having some difficulty with my computer. Joelle, if you're able to run the slideshow.
I think I can do it if it's not working. Yeah, so hang on, let me see if I can share my screen. Oops. Can everybody see that? Hunter?
I see it.
Okay, great.
Yes, that looks good.
Okay. Alex, can you control from your end?
Yes, I can.
Okay, so I'll just prompt you when to hit the next slide. So as mentioned, today I will be presenting on Senate Bill 54. And before I kick us off, I want to make clear that our office is the state's law enforcement entity responsible for enforcing Senate Bill 54. And we do that primarily through three ways. One, we do that through investigations. Two, through litigation, if needed. And then finally, and by and large, this has sort of been a big focus of ours, and it occupies a lot of our work, is through guidance and technical assistance to law enforcement agencies. Next slide, please. So before I go into the California Values Act, I want to start with the Trust Act. In 2014, California enacted the Transparency and Responsibility Use State Tools Act, also known as the Trust Act, which limits how local law enforcement agencies cooperate with federal immigration authorities, particularly Immigration Custom Enforcement Detainers, or ICE for short. The Trust Act was created to ensure that immigrant community members are not detained by local police solely for immigration enforcement purposes, except in cases involving serious or violent crimes. It aims to build trust between immigrant communities and local law enforcement. Some of the key provisions of the Trust Act include, under the Trust Act, local law enforcement cannot hold individuals beyond their release date based on an ICE detainer request unless that individual has been convicted of a serious or violent offense specified under the law. The Trust Act prioritizes keeping dangerous offenders detained, but prevents unnecessary detentions of people for minor offenses or no crimes at all. The Trust Act makes clear that compliance with ICE detainers is not mandatory under federal law, and the Trust Act helps California jurisdictions avoid potential liability for unlawful detention since ICE detainers are not judicial warrants. Next slide, please. In 2017, the legislature expanded the protections under the Trust Act when it enacted Senate Bill 54, also known as the California Values Act. The Trust Act, as amended by SB 54, now describes the circumstances under which California law enforcement agencies can engage and cannot engage with immigration authorities. In enacting the Values Act, the legislature made clear in its finding that immigrants are valuable and essential members of the California community. The legislature further determined that a relationship of trust between California's immigrant community and state and local agencies is central to the public safety of the people of California. Thus, the core purpose of the California Values Act is to ensure effective policing and to protect the safety, well-being, and constitutional rights of the people of California. So what is it that SB 54 does? It does a few things, but I'm going to start sort of in general broad strokes. It sets the parameters under which California state and local enforcement agencies, including the California Department of Corrections and Rehabilitation, or CDCR, can and cannot engage with federal immigration enforcement. The Act also requires the California Attorney General's Office to issue model policies to be adopted by schools, public schools, state or locally operated healthcare facilities, courthouses, and other enumerated state and local facilities that limit assistance with immigration enforcement to the fullest extent possible, consistent with federal and state law. Our office issued these guidances in 2018 and then updated those in December 24. The Values Act has some key definitions. including how it defines California law enforcement agency to mean a state or local enforcement agency, including school, police, or security departments. What is key about this term is that SB 54, much like RIPA, is a regulation of state and local law enforcement. And like RIPA, SB 54 does not regulate federal law enforcement, including ICE. It also defines immigration enforcement to mean any and all efforts to investigate, enforce, or assist in the investigation or enforcement of any federal civil immigration law, and also includes any and all efforts to investigate, enforce, or assist in the investigation or enforcement of any federal criminal immigration law that penalizes a person's entry or presence in the United States. Key with this term is that the definition of immigration enforcement encompasses both civil and criminal federal immigration laws. Next slide, please. The Values Act limits the discretion of California law enforcement agencies to participate in immigration-related activities in the following ways. One, it prohibits the use of resources to investigate, interrogate, detain, detect, or arrest persons for immigration enforcement purposes. This prohibition is key because this is a limitation on the law enforcement agency or the local, county, or state entity that oversees the law enforcement agency. The California Values Act has several prohibitions. It prohibits inquiries into a person's immigration status. In other words, a police officer cannot ask a pedestrian or a driver about their immigration status. California Values Act prohibits detaining an individual in response to a hold request. And a hold request means a request by immigration authority to a local law enforcement agency to maintain custody of an individual currently in the custody of the law enforcement agency beyond the time he or she would otherwise be eligible for release to facilitate transfer to an immigration authority. In other words, a police officer or police department cannot detain a person long enough for ICE to take custody of that person. The California Values Act prohibits the provision of personal information or the sharing of personal information. This includes home or work addresses, unless that information is already available to the public or if it does not violate privacy laws. For purposes of this prohibition, personal information means any information that is maintained by an agency that identifies, describes an individual, including his or her name, social security number, physical description, home address, home telephone number, education, financial matters, and medical or employment history. This includes statements made by or attributed to an individual. What this means is that law enforcement agencies cannot provide personal information about an individual unless that information is available publicly, such as by posting on the law enforcement agency's website. This exception is constrained by state and federal privacy laws, as I mentioned. California Values Act prohibits the making or participating in arrests based on civil immigration warrants, which means any warrant for violation of federal civil immigration law and includes civil immigration warrants. And the California Values Act prohibits assisting immigration authorities in immigration enforcement activities or performing the functions of an immigration officer. Under SB 54, California law enforcement agencies cannot honor, transfer, or notification requests or provide information regarding a person's release date, except under certain circumstances. A police department can honor transfer requests only if, one, the transfer is authorized by a judicial warrant, or there's a judicial probable cause determination, or two, where the transfer would not otherwise violate any federal, state, or local law or policy, and the individual in custody was previously convicted of serious crimes or violent felonies. Those prior criminal convictions are enumerated in the civil code, and I'm not going to go into those convictions because it's pretty long and I'm short on time, but this is really to explain the circumstances under which agencies can honor transfer requests. If a law enforcement agency does transfer an individual to immigration authorities, the Values Act requires the agency to report to the California Department of Justice the number of transfer it makes in a calendar year, as well as the offense that allowed for the transfer. SB 54 allows law enforcement agencies to provide information regarding a person's release only if that information is available to the public, i.e. is posted on the agency's website, or that, again, that individual has certain enumerated prior serious violent felony convictions, or the individual has been arrested and taken before a magistrate judge and on certain charges, and the magistrate makes a probable cause determination for the charge. A law
Joelle?
enforcement agency. Yes, Andrea.
I'm sorry to
please, ma'am.
interrupt. I'm getting some messages that folks are having trouble with the audio. So I wanted to see if, I don't know if we need to,
Amazing.
something on your end. Let me ask, I see that John Debar and a member of the public is having problems. Andrea,
Can
are
you hear
you
me
able
now?
to
Is
hear?
this better? Try to move
I
this
can
up a bit. Is this better?
think that might be a little better. Okay, so I'm seeing, okay, others are not, so maybe individuals can maybe log out and return. That may help. Okay, so I just want to make sure everybody has the benefit, of this presentation. Okay, and Andrea can hear fine. Okay, why don't we just give it a minute, and then if folks want to log out and in, and then we can resume. That would be okay with you?
Yes, I'm gonna join by phone.
Okay. Okay, it looks like others are also able to hear, so. Okay, we can resume. Thank you.
You can hear me now, right?
It's echoing now.
Okay.
I think maybe just do it as you were doing. I think as you had it was fine.
Okay. Is it still echoing now?
That's fine. Yes.
Okay, perfect. So I will proceed. SB 54 allows law enforcement agencies to provide information regarding a person's release date, and I just went over those a minute ago. Other restrictions on immigration enforcement. California law enforcement agencies cannot, 1, allow officers to be supervised by federal agencies or deputized for immigration enforcement purposes. 2, use immigration authorities as interpreters for law enforcement matters relating to individuals in custody. 3, provide office space exclusively for immigration authorities in city or county law enforcement facilities. Or 4, enter into a contract after June 15, 2017 with the federal government to house or detain adult and minor non-citizens in a locked detention facility for purposes of immigration custody. Agencies with existing federal contracts cannot renew or modify the contract if doing so would expand the number of contracted beds available to detain non-citizens. Next slide, please. If an agency policy or a local law or policy permit, a California law enforcement agency has discretion but is not required to perform the following. 1, investigate, enforce, detain persons upon reasonable suspicion of or arrest persons for violations of 8 U.S.C. 1326A. This is a federal law that criminalizes reentry by a non-citizen after removal. B, law enforcement agency can provide criminal history information in response to requests from immigration authorities about a specific person's criminal history, including information obtained from the California Law Enforcement Telecommunication System, or CLETS for short. Through this system, law enforcement agencies can exchange information. However, law enforcement agencies cannot exchange certain categories of information, such as personal identifying information, which can include DMV information. SB 54 allows law enforcement agencies, and this is something that was mentioned previously, to participate in joint law enforcement task forces with federal authorities, including the sharing of confidential information with task force participants if the following conditions are met. 1, the task force's primary purpose is not immigration enforcement. 2, enforcement or investigative duties are primarily related to the violations of state or federal laws unrelated to immigration enforcement. And 3, local law or policy allows such participation. So the key provision with the task forces, and I do want to emphasize this, that if they're primarily for the purpose of enforcing federal immigration laws, SB 54 does not allow it. If the secondary purpose of the task force is to enforce civil immigration laws, SB 54 allows that. And that is sort of the loophole that was identified previously by Andrea, I believe. She sort of previously discussed task forces and the loophole within SB 54. If an agency participates in a joint task force with federal immigration authorities or federal authorities, the agency is required to report information regarding the joint task force to the California Department of Justice. SB 54 also allows law enforcement agencies to ask information necessary to certify potential victims of crime or human trafficking victims with respect to T visas and U visas. Lastly, law enforcement agencies can provide ICE with access to interview an individual in custody if the agency gives that individual an opportunity to consent in writing. Note, nothing in the California Values Act prohibits a law enforcement agency, a California law enforcement agency, from asserting its own jurisdiction over criminal law enforcement matters, i.e. engaging in an investigation, detention, or arrest for criminal activities based upon California state law, even when its activities may indirectly impact or assist a federal agency that's engaged in immigration enforcement. This includes circumstances in which an officer responding to a call for service involving a violation of a state criminal law during an immigration enforcement action, or where the safety of the public or the law enforcement officer, including an immigration enforcement officer, is in danger. This narrow public safety exception should not be used to avoid the prohibitions in the California Values Act. The California Values Act does not prohibit a law enforcement agency from exchanging information regarding a person's immigration status with governmental entities, including immigration authorities, for requests made under 8 U.S.C. Section 1373 and 8 U.S.C. Section 1644. Under those federal statutes, no person or agency may restrict the ability of a federal, state, and local entity, including law enforcement, from sharing information about a person's citizenship or immigration status. One thing to really flag here is that the Ninth Circuit narrowly construed these the prohibitions under 1373 to apply only to immigration status. That is, state law can restrict local law enforcement agencies from sharing PII, say, with federal authorities, but the state cannot restrict the sharing of immigration status or citizenship status information with the federal government. Next slide, please. So a bit on so there were questions about technologies and information, so I'm going to go into a bit about that. The California Values Act does not ban the types of technologies that law enforcement agencies can use, but it does limit the use of local and state resources, including technological systems, databases, and information sharing tools for immigration enforcement purposes. Again, the Values Act generally prohibits law enforcement agencies from using resources or personnel to investigate, interrogate, detain, detect, or arrest persons for immigration enforcement purposes. And applying this rule, if the purpose or use of a particular technology is to assist or engage in immigration enforcement, the use of that technology is generally prohibited. So for instance, a law enforcement agency cannot contract with or allow ICE to use local surveillance technology, such as facial recognition systems, license plate readers, and security camera networks or monitoring systems for immigration enforcement purposes. Law enforcement agencies cannot use communication technologies like dispatch systems to notify ICE of release dates or the location of individuals, unless that person meets a serious or violent felony prior conviction. And California law, specifically Senate Bill 34, prohibits local law enforcement agencies from sharing data collected via automated license plate readers with out-of-state or federal agencies for immigration enforcement purposes. SB 34 does not, as I mentioned, does not permit the sharing of ALPR information with private entities as well, or out-of-state federal agencies, including out-of-state federal law enforcement. This prohibition applies to ALPR databases that LEAs access or law enforcement agencies access through private or public vendors who maintain ALPR information collected from multiple databases or public agencies.
I know I have about 3 minutes left and the AG slated to join us. I have a few more slides here about our office's litigation around immigration conditions to federal funding. I would actually like to put a pin in that in case the AG is actually able to join us in 3 minutes and turn it back to the board for any questions or reactions to the SB 54 presentation. If the AG runs late, I am happy to turn back to these slides and talk a bit about the litigation.
Great, thank you. Thank you, Joel. And it looks like, does it look like the Attorney General will be joining us momentarily? I see on my screen.
I believe we have a few more minutes. So if you have any questions for Joel, board members, please feel free to jump in.
Great, thank you, Yasmin. So any board members with questions with respect to Joel's presentation? So a lot of information. You see if I see.
Folks don't have questions, talk a bit about the litigation, because the thing with SB 54 is that our enforcement of SB 54 is both affirmative and defensive. The state has been sued by local entities regarding the constitutionality of SB 54, and SB 54 has been upheld as lawful. But during Trump 1, and now really recently over the past few months, we've litigated a number of cases, a number of challenges against the federal government, where the federal government sought to impose conditions on funding to state and local entities that would have essentially required state and local entities to violate SB 54. Say, for instance, we brought litigation against the United States Department of Transportation. It wanted to condition billions of funds to states and impose terms and conditions that would have required recipients to honor ICE detainers or honor ICE requests to transfer individuals, or would would require grantees to cooperate with ICE in a way that violates state law. And so this past year, we brought a number of lawsuits against a number of federal agencies, including the U.S. Department of Transportation, the Department of Homeland Security, and most recently against the Department of Justice, United States Department of Justice, to challenge the agency's attempts to unlawfully impose conditions on funding to states. And these are by and large formula grants. These are not discretionary grants generally. So these are grants that where Congress has determined what the purpose is for and what the criteria for receiving those funds are. And nowhere in those appropriation statutes did Congress require cooperation with federal immigration enforcement. And so we brought a number of lawsuits, including applications for preliminary injunctions. There, by and large, we have prevailed in a number of those preliminary injunction motions. Some of those cases right now are on track to be decided at summary judgment. So we filed an expedited motion for summary judgment in our litigation against the Department of Homeland Security. That is pending with the court. We also brought one in our Department of Transportation litigation. That is pending with the court. And so this is just really to highlight for you the sort of the various ways in which SB 54 can be implicated in our litigation, and the ways in which the federal government is attempting to conscript local and state resources for federal immigration enforcement. And so the thing that's really important here is that a lot of the focus, of course, is what's happening on the ground. What is it that ICE is doing on the ground that may or may not have an effect on local law enforcement or state law enforcement? But there's also a lot happening behind the scenes in terms of the funding that a lot of local and state agencies receive that could potentially impact whether law enforcement agencies or local and state agencies comply with SB 54 or agree or are conscripted by the federal government in its immigration enforcement policies and initiatives.
Thank you. Yeah, I have a question that has in follow-up to a comment earlier. You know, you had noted that the Department of Justice with respect to the Values Act, you know, is kind of three-prong kind of focus: investigation, litigation, guidance, and technical assistance. So with respect to investigation, I think someone had asked about like if people are aware, you know, they believe there's been a violation of the Values Act. Members of the public or anybody, they can lodge a complaint, right, or a concern with Department of Justice, correct?
That's right. We have an online complaints portal that any member of the public can use to report what, observations that of violations of law, or if they believe, they're not sure, but they believe there might be a violation of law, members of the public can access our website or use our website to enter that complaint information.
Thank you. Any questions from the board for Joelle? And while we're waiting to see if there is any additional questions, do you want to maybe talk a little bit about the third prong of the focus of Department of Justice, the guidance and technical assistance?
Angela, I think the AG's on. Am I correct?
Great.
Yeah.
Oh, great. Okay, let's hold.
Hey, Rob's here. Hi.
Attorney General.
I'm here.
Hello. Oh, Attorney General Bonta. Hello, and thank you so much for being with us today. This is Angela Sierra with the Department of Justice and your designee on the RIPA board. So we really are very thankful for your time today as we're exploring this issue about racial and identity profiling in immigration enforcement and the challenges that we are facing as a state and potential roles of this board. So let me turn it over to you.
Awesome. Well, thank you. And I'll make a few remarks at the outset and happy to take questions and have a conversation. I at the outset do want to just say thank you, Angela, for the introduction, for your work on the RIPA board. Thank you to all of you who have committed your time, your talent, your insight, your passion to the very important work of the RIPA board. This is one of those places for me when both my role as an assembly member, as a state legislator, and my role as an attorney general kind of connected. I was a co-author with Dr. Shirley Weber of the RIPA, of the Racial Profiling Act, and then now have the opportunity to work to enforce it and make sure that it's implemented in the most impactful and effective way. And the data you have collected and the insights that you have shared and the policy that you have proposed based on that evidence, based on that data, evidence-based policies, data-driven policies, has all been super helpful and impactful in advancing more justice and tackling discrimination in its many forms. So I want to start with a big thank you for all of the work that you've done. And I know Joel just did a great job. Thank you to Joel of providing an overview of SB 54 and how that operates in California, our pro-public safety, pro-community trust approach. And it is good law, it is constitutional, it is unlawful and unconstitutional for the federal government to try to force or coerce or commandeer the resources of the state of California to participate in their immigration enforcement approach. We want to focus on crime, we want to focus on trust, and SB 54 encompasses that and is fully constitutional. That's not my opinion, that's the decision of the Ninth Circuit. And so SB 54 is good law and must be followed in California. And I know we want to talk a little bit about racial profiling in immigration enforcement. And unfortunately, we have seen racial profiling in immigration enforcement by the federal government. It appears that the federal government is not just condoning it, allowing it, permitting it, but ordering it. And it's part of their approach to their immigration enforcement. And again, this is a administration that started, has declared and stated and articulated, and continues to articulate that they're focusing on violent criminals who are illegally present in California. And the data shows the opposite, that they are actually stopping and searching and detaining folks who are lawfully present, who are not violent either. and have no criminal record. So it's unfortunate and devastating and painful and I believe unlawful and unconstitutional what's happening. There seems to be no shame in adopting a racial profiling approach to immigration enforcement, no shame in violating blatantly and brazenly the Fourth Amendment of the Constitution, which only provides for reasonable searches and seizures. No shame in targeting people based on the language they speak, how they look, the occupation they appear to hold, their location, their presence in a certain place in Los Angeles or in California, and no shame in destroying trust between communities and law enforcement, no shame in hiding who they are by covering their faces and masking, removing their license plates, as we've seen, and not providing humane, transparent law enforcement. And there was a lawsuit on this very issue, the issue of racial profiling by ICE, by the federal government. And a federal judge, I believe, nailed it in her order in reviewing the conduct of federal immigration enforcement officials on the ground in LA, what they were doing, what they were relying on. And she issued an order saying that the federal government may not, because it violates the Constitution, rely on race or on language spoken or on presence in a certain location or on perceived occupation. Any one of those elements or any combination of them to stop and detain and search and seize individuals in LA. And that was the judge's order. And as some of you know, all of you know, that order was appealed to the U.S. Supreme Court, not on the merits, but on what's known as the emergency docket or the shadow docket, where a request was made to the Supreme Court to put a stay, put a halt, put a block on that order while the case continued. And the U.S. Supreme Court didn't need to, but decided to block that order from being implemented. One of the problems of the shadow docket, of the emergency docket, is you don't know who voted for the stay, and you don't know their reasoning or rationale. You do know that it's a majority because it has to be a majority. But there's very little transparency. There's no written opinion. There's no a majority opinion, that is. There's no guidance provided to the federal court for how to comply with what the U.S. Supreme Court has seen. So it's and this emergency docket has been used often since Trump has come into power, often blocking the lower court's decisions below without any guidance or any rationale. But what we did see was a concurrence by Justice Kavanaugh and a dissent, a very fiery dissent by Justice Sotomayor. And I think the concurrence of Justice Kavanaugh was very disturbing and dangerous, and I believe unconstitutional in its rationale. Basically said you can rely on race to stop or detain people in California. That racial profiling essentially is constitutional, and it's okay to stop people, detain them, search them based on perceived race and the other elements that were in the order. And I think Justice Sotomayor really nailed it when she said we ought not live in a country where the government can seize you based on looking Latino, speaking Spanish, or the perception that you work in a low-wage job. And I agree, we shouldn't live in such a nation. And the concurrence, although not the majority opinion, the concurrence of Justice Kavanaugh was very dangerous. So it's a dangerous decision. It doesn't leave no next steps, especially without the guidance. There can be ongoing litigation. That was the Supreme Court's decision on a restraining order. There's still the opportunity for a preliminary injunction, permanent injunction, final decision after a trial. And we'll see how that issue plays out. But one important observation I want to make is that when individual rights are violated, the Fourth Amendment, for example, based on a false arrest or excessive force or racial profiling. The remedy, the ability to seek a remedy, usually almost always lies with the individual. So the individual needs to sue. And it could be a class of individuals, it could be a single individual, but almost never is it the Attorney General's office. And we do not have standing in those cases. We do have an interest in those cases. And we filed an amicus brief in the Central District of California's case that I just discussed. That went up to the Supreme Court and was ultimately stayed. And we supported the ultimate trial court decision that race should not be considered, or language, or location, or perceived occupation as appropriate and reasonable elements to consider for searches and seizures. And we will continue to participate in that regard going forward. So that's kind of the state of play right now, with more ability going forward to take action, but mostly lying in the hands of individuals who are wronged, whose constitutional rights are violated. When the rights are violated, they can vindicate them. They need to go to court to do so. And we do have groups like the ACLU and others who are assisting with those cases to make sure that these important issues are brought to the court and decided on appropriately. And again, I want to say thank you for the work that you're doing, and what California does often leads the nation. That phrase that we've heard so many times: as California goes, so goes the nation. So thank you for leading. California is the most diverse state in the nation. We're proud of that fact. Over 67% of all Californians are people of color. Our state is home to nearly 11 million immigrants, 27% of the population, and my own mom included. And that diversity is our story. It's our strength. We have learned to live and thrive with our diversity. We're not successful in California, becoming the fourth largest economy in the world, the largest state in the nation. In spite of our diversity, it's because of it. And we need to continue to embrace our diversity and make California a place where everyone is included, supported, they have their rights honored, and can thrive, can go to school, can go to work, can be safe in their neighborhoods, can be safe from unlawful, unconstitutional stops and searches and seizures. And so we have more work to do. And when I make these comments about California, our future, our values, our aspirations, I don't just say it as an attorney general. I say it as someone who was born in a different country myself, and who has a mom, as I mentioned, who's an immigrant, who was born in I was born in the Philippines and was brought to California when martial law was around the corner and democracy was teetering on the brink, and was eventually toppled by a dictator exactly a year from the date of my birth. And free and fair elections were over, and my parents wanted for me democracy and freedom and human rights and civil rights, due process, the rule of law, and that was being taken away in the Philippines. So they brought me here to California, where they thought I could pursue, hopefully realize one day, my California dream, my American dream, where I could live with freedom, with democracy, with civil rights, with the rule of law, with due process, as it was getting taken away in the place of my birth, and where political opponents who dared to speak out were arrested and imprisoned, tortured, and killed, where free and fair elections were over and democracy was gone. And so we thought, my parents believed, and I believe, that this is where those values and those principles thrive, and they also need to be defended and protected. And we can't just assume that they will be ever present, but each generation needs to continue to fight to make sure that they are available to the next generation. So you're part of that effort to make our state more fair, more just, more constitutionally compliant. And the work of this board is absolutely critical. And so I do think that there are some things that you could do when it comes to addressing the concern around racial profiling by immigration enforcement officials, federal officials. The same approaches that you've taken in the past to collecting data and presenting data and analyzing data could be helpful here. It could be interesting to get a full picture of the scope, scale, nature of racial profiling by federal immigration enforcement officials and the impacts that it has on the community. Collecting data on officer interactions and with federal immigration enforcement as it relates to stops or calls for service, analyzing RIPA data to identify areas where additional guidance could be needed for local law enforcement or members of the public. Just looking at stops, looking at seizures, looking at detentions, and looking at who is being stopped, searched, detained, as you've done in many other scenarios throughout the state as part of your ongoing work. I think that same approach could be appropriate here when it comes to understanding, getting our arms around the impact of the racial profiling of our federal officials and helping that data inform next steps and action, policy changes. So let me just end with that, which is a thank you. A look forward to the potential work that this board may do to address the issues that you're seeing in real time emerging in our communities throughout the state of California. This is an incredible group of law enforcement representatives, advocates, and community leaders, government officials, nonprofit folks, all coming together with a common goal to address profiling in our community and help provide guidance and shine a light on pathways forward to address those challenges. So please continue to do the great work that you're doing. Again, as Joel explained, I just want to emphasize SB 54 is the law of the state of California, and the federal government cannot commandeer us or conscript us or draft us into service to do their job for them. They may do their job. They must do it lawfully, and we've seen them act unlawfully, and there needs to be accountability for that in court, but they cannot force the law enforcement resources and law enforcement personnel of the state of California to do their job for them. SB 54 continues to be the law of the state of California. And with that, I'm happy to answer any questions that you might have with much gratitude for all the work that you're doing.
Wonderful. Thank you so much, Attorney General. Thank you for your time, and thank you for your leadership on these really critical, serious, and really challenging issues. And this is really helpful to us as a board in trying to see what we can do to help in looking at our mission and what areas that there are gaps that we can contribute. And you gave us a lot of really helpful information to work with. So I see we do have some questions. I really thank you for staying on with us. I see that our co-chair, Andrea Guerrero, has her hand raised, so I'll turn it over to Andrea.
Great. Thank you. Attorney General Bonta, it's good to see you again. Thank you for your leadership, for the litigation in particular. And yeah, I think a thought and a question really, the work that law enforcement agencies do to collect stop data here, state and local agencies, is really critical. I know that federal lawmakers are looking at RIPA as a model to do the same for federal agents. Because of the supremacy clause, as you pointed out, we can't tell them what to do or how to do it, but they've got to do their work within the Constitution. And of course, we've learned that the stop data has been helpful to the lawmakers and to others stakeholders. And so hopefully we can get something similar going at the federal level, if not in the short term, then in the longer term. I wanted to ask you, criminal prosecution. You talked about civil lawsuits, and you talked about the people who have the best standing in civil litigation are individuals, and that makes sense, right? The directly affected community. But we just had a really rich conversation about the role of law enforcement in California and prosecutors to bring charges where there are egregious violations of the Fourth Amendment, say, and there are grounds under the California Penal Code to to make arrests and to do investigations and to bring charges against agents for kidnapping or for assault, battery, felony assault, battery, child endangerment, elderly endangerment. And we had with us Chief Manuel Rodriguez, who's still on screen here. But I wanted to see if you could respond to the potential for prosecution. We know that district attorneys have a role to play as prosecutors, but so does your office, right, in bringing prosecution. And I know this is perhaps something that we all haven't had to contemplate in the past, but now we do. So your thoughts. Thank you.
Yeah, thank you. First, I'll say we are ready, willing, interested in providing criminal accountability when we can meet our ethical standards and legal standards of bringing a case that we believe that we can prove to a jury beyond a reasonable doubt and secure a conviction. And it's a high standard. That's the standard we always follow in any and all of our cases, and DAs are required to follow that standard as well. There are some unique challenges when it comes to the State Attorney General's office prosecuting a federal officer for criminal conduct. It's not impossible. It's not barred. It's not prohibited, but it's difficult. And one part that makes it difficult is that if we bring the case under the law of the United States, federal law, the case can immediately be removed from state court, where almost all state criminal cases in the state of California are brought, outside of what the U.S. Attorney's Office brings into federal court in their capacity. But DAs and AGs who are bringing criminal prosecutions based on the California Penal Code do that in state court. So the case could be removed immediately by right to the federal court, and then usually when we bring a case, we have the goods, so to speak. We have the receipts. We have the evidence. We've done our investigation. We don't need anything else. We file because we know we have the ability to prove the case beyond a reasonable doubt in court. And a lot of what we're seeing right now, we have an information deficit, meaning we don't even know sometimes who the officer is, like the immigration officer, like they're masked. We may have an ability to see video that shows their ID. We may not. We may know, we won't have a chance to get full information or files. The federal government is not necessarily a willing, cooperative partner here to providing us data about who the person is, what they were doing, what their mission was. So sometimes we don't even know who the defendant is, much less have all of the evidence to be able to bring a case beyond a reasonable doubt. I will say, without commenting on any specific investigations or pending investigations, that we have looked specifically at some incidents and used our high standard that we use all the time, and decided, at least for now, that it was more prudent not to bring a case at this time, based on what we believe we could prove in court. But it's not because we don't wish to, not because we won't, and not because it's not important. It's all those things based on the facts that we're able to prove. So we will continue to play our role in looking at potential criminal conduct by federal immigration enforcement officers, and when we believe that we can bring a case and meet the standard required in court to secure a conviction, we'll bring a criminal case. But that hasn't happened at this time.
Thank you. Are there any other members of our board who would like to ask a question of the Attorney General, or just to have an observation they'd like to share? And after this presentation, we will move into our board discussion. See, we have a question from board member Kazi.
Thank you so much, and thank you, Attorney General Bonta, as well as Joel, for your presentations. My question is more towards the enforcement of SB 54, the California Values Act that Joelle mentioned. What has that enforcement looked like against local law enforcement agencies in terms of the information sharing, perhaps engagement in civil immigration enforcement? And the second part to that question is, there was a mention of how civil immigration enforcement may be allowed if it's the secondary purpose of a joint task force operation. So also, is there any oversight of whether or not it was in fact the secondary purpose? Our report that we'll be discussing next week spends a lot of time talking about pretextual stops. So in terms of, a primary purpose serving as a pretext for that secondary purpose or that immigration enforcement, what does oversight of that look like?
Yeah, great question. Thank you. I'll first say that our office has the ability to enforce SB 54 if it's not being complied with by law enforcement agencies or departments. And we issued guidance as the Trump administration was coming into office and the inauguration neared, reminding our law enforcement agencies and departments what SB 54 prohibits and requires, what its exceptions are as well. Just a objective review and sharing of what SB 54 is, and that it is alive and well. It's the law of the state of California, and we expect it to be complied with. And we've definitely heard some law enforcement leaders in some places talk about disagreement with SB 54. There's even some lawsuits challenging SB 54, but we haven't seen the action of violating outright SB 54. And should we see that? And we've chased down reports. There's people who've seen a head of a department or an agency say things that are disturbing in terms of not wanting to or not intending to comply with SB 54, but saying things is one thing, doing things is what we really focus on, the action. And so we're prepared to take any entity that doesn't follow SB 54 to court if necessary, but we haven't seen that yet. We're still open to reports and sharing what people are seeing on the ground. We'll always do our own independent analysis and review, assessment and evaluation. But we are prepared to enforce SB 54 if necessary, but we expect law enforcement who enforces the law to follow the law and to comply with SB 54. On the joint task force issue, we have made clear that in the language of SB 54 requires this, that if the primary purpose is not immigration enforcement, you may participate. My office participates in task forces where we were just part of one where we took down a criminal organization that was involved in fentanyl smuggling and gun trafficking and RICO and violence, including attempted murder and murder. Nothing to do with immigration enforcement. And tackling crime is what SB 54 is focused on, using the resources to tackle crime. If there was an example where it's all just an illusion and superficial, that the main purpose of the Joint Task Force is to enforce criminal violations, but what it's really doing is creating pretexts for pretextual stops or pretextual searches to do immigration enforcement, and that's really and the primary purpose is immigration enforcement, then the primary purpose of that task force is immigration enforcement. Despite what you say, it's what it is, not what you say it is or what words you use to describe it. You got to get down to the substance and past any potential titles that are suggesting that the task force is something that it's not. So the law doesn't change on that. You got to get down to what the primary purpose is. And if the stated purpose is not the primary purpose, then the primary purpose is the primary purpose. And if that's immigration enforcement, then local and state law enforcement agencies can't participate in them. But we would need to be advised or get some evidence or conduct an investigation to really get down to the substance of an issue like that. That requires a fair amount of due diligence and deep diving.
Thank you. I don't see any other questions. Oh, we have a question, Chauncey, Board Member Chauncey Smith.
Yes, thank you, Angela. I don't actually have a question. I just wanted to say thank you to the Attorney General for your leadership on this issue, protecting the rights of immigrants and defending the rights of Californians against the oppressive and authoritarian acts of the Trump administration more generally. So I just want to show some appreciation.
Thank you, Chauncey.
Thank you, Chauncey. Okay, and let's see, we have a hand raised from Board Member Armelin.
Yeah, I just wanted to jump in and second Board Member Chauncey Smith as well, to thank AG Bonta. It's good to see you again, Bob. To thank AG Bonta and his dedication to this issue. And I guess I would just urge AG Bonta and his office and anyone to get in contact with us or members of the board if there's any way for us to assist in any of these efforts, either individually or as a group, that this kind of maintains and sort of ongoing open channel of communication.
Sounds good.
Great, yes. Thank you, Board Member Armelin. Yes, you know, as we continue to want is an important partnership between our board and the Department of Justice. So with that, I will thank you again, Attorney General. We really appreciate you being here with us. This has been extremely helpful, and thank you for everything you're doing.
Thank you, everyone from a grateful state and Department of Justice and Attorney General. I appreciate your work, your service, your commitment to the ongoing, very important work of the RIPA board. I know your time is valuable and your talent is valuable. Thank you for sharing both with the RIPA board and in service to the state. Honored to serve alongside all of you. Thank you for having me.
Wonderful. Thank you. Okay. Well, thank you so much, everybody, for being here for that presentation. And Joelle, I want to turn it back over to you if there was any final thoughts on your presentation, or if we have any questions of Joelle with respect to the slides that he was working through during the earlier segment of this panel. Let's see if he comes back on.
I'm on, Angela.
Okay, great. For some reason, I don't see you. Okay, so was there anything, did you have any additional thoughts you wanted to share before we moved to any additional questions or our board discussion?
Nothing else, but what I'll do is in the chat, I'll drop a link to our office's publications, and there you can find not just the model policies and guidances that our office issued under SB 54, but you would also find guidances to our law enforcement agencies, very detailed guidances on how they're to not just comply with SB 54 and the task force provisions, but also the data reporting mandates under California law. So you could, when board members and members of the public have the opportunity to, you can peruse those materials because you will find everything that I presented on really largely came from the guidances. So you're free to study those as well.
Wonderful. That'd be very helpful, because I think that, as you had mentioned, is a really important, aspect of the work of the Department of Justice. And as the Attorney General, noted, that may be an area for some additional work from the board or some assistance on the board on that aspect of enforcement of the Values Act. So thank you. Okay, well, that was really wonderful. I think today we've really learned so much. This has been a very rich meeting. We're going to move now to the next agenda item, which is our board discussion, which we had started a bit ago after our first presentation. And again, an opportunity for us. If there's any other observations from our board members, thoughts. I mean, a lot of this, I know it's evolving and we're thinking through. We may just be thinking out loud a bit about how we may be moving forward as a board on these issues. And I'm sure we will be continuing to talk about that at our next board meeting. But anyway, I want to open it up to our board members to the extent there are some additional observations or thoughts with respect to the last presentation or just, this issue in general. So I'll see if there's any hands up. Okay, board member Kazi.
So I think one of the things we've identified in our earlier discussion was there seems to be a policy gap. And one thing I just don't quite have a grasp on is whether and to what extent there is a gap in terms of the enforcement of SB 54, whether or not it's being violated by local law enforcement agencies, and whether that's just not occurring to the extent. So I heard Andrea, board member Guerrero, you mentioned a couple instances that occurred in San Diego. This summer, I got something that came across my desk that I'm looking into more. And so is there just a gap of it moving up the pipeline to DOJ? And I don't know to what extent that's happening and whether it is just a matter of us, putting in a framework to gather that data and to facilitate that complaint process.
Yeah, good point. Is it, well, let me turn over to Andrea. She was talking about what was happening in San Diego. Andrea?
Yeah, I'll just say that the way the SB 54 is written, the Attorney General has direct responsibility, as he mentioned, to enforce SB 54. So if there are agencies that are not complying, it's important for us as community members and stakeholders to identify those and bring those to the Attorney General's office. And as Chief Rodriguez mentioned, the Attorney General has taken El Cajon to court for their lack of compliance with SB 54. So I think there's no policy gap with regard to enforcement, right? Like, it's a matter of getting that information to the AG so the AG can enforce. Where I see the policy gap is more around that tension that Board Member Diallo stated, which is it might not even be a policy gap, it just might be a protocol and guidance gap. How should officers respond when they are called in to mutual aid or called for service by community members, and they're balancing the tension between their responsibilities to do those things and their responsibility to intervene, and doing it in a way where the expectations are clear for everybody. So for example, and I think this is like a rich area for us to really dig into in the coming year, like the life cycle of our report is such that, we don't have enough time to gather the information we need to create a section in the report for this. Certainly we can, what I would recommend is we just reflect the conversation that we've had, but I think next year we should actually dig more deeply into this and think about what the data tells us about what's going on, and we'll have much more information going into next year. I mean, the only data we collect right now that could be useful is if there is a pass off, or it's not described as a pass off, but if there's an interaction with a federal law enforcement agency, that's recorded, and we use that now to track that against the reportable transfers to make sure there's no violation of SB 54. So that's really helpful to us. And, we can think about whether the data tells us anything else about what's going on. But it could be that in a future year, we think about whether we actually need another data point to collect, and that would be a change to the federal regulations, or it could be clarifying things in state law that don't specify enough what the duty to intervene is vis-a-vis federal agents. So those are some thoughts and reflections.
Thank you. We have Board Member Kulkarni, your hand up.
Yeah, I was actually going to make a similar comment, and so I just wanted to second what Co-Chair Guerrero said, which is I think it would be important, you know, as we address board members Kazi and Smith's sharing of, you know, information and data around these lapses or the gaps, as they were called, between policies and adherence to those policies, that we take a deep dive and look at all both the data as well as investigations done by journalists as to what is happening on the ground. So thank you.
Thank you. See, do we have any other questions or comments from our board members? Okay. Oh,
sorry. Yeah.
Go ahead.
Could I just make one other comment, which is that I do think that it would be important to take the work that's been done and shared today and find an appropriate mechanism to include that in, if possible, this year's report. So whether it is, you know, the actual presentations and or material that is currently available to show what has happened in Los Angeles and other parts of the state in terms of ICE enforcement, and to also talk about what was, you know, in the shadow docket, the case and the order that were discussed both before and by AG Bonta, and so that there, I think, given what has happened in the past 9 to 10 months, that it would be important that we include that in the report, even though we may not have all the data at our disposal now, because that, you know, our report comes out in January of every year, and so it's a look back at the past year. So I do believe it would be critical to include whatever we can in terms of data, investigations, and our analysis of it. Thanks.
Thank you. Let's see, any other comments, observations from our board members? Okay, let's see. Oh, yes, Board Member Kajabi.
I guess this is a comment or question to the whole board. I hope we can talk more about what we as a board can do. I really appreciate all the suggestions about the report, but as was, you know, as we're reminded, the timelines that go into the report and so on make them, I mean, I think they're critical and very important in one way, but they just don't move very rapidly, and now we're in a situation where things are moving so quickly, and so I'm curious what other suggestions and ideas people have. Like, for example, in the past, as we did today, this is a community forum space, and I'm thinking about the experiences that folks are having now, you know, not just with the ground has shifted in many ways, but they included the tactics, the things we're seeing now. For example, people in masks showing up with license plates obscured and their identity obscured. And that's, that's not something that we have members of law enforcement on this very board, and that's not how those agencies are operating. And so, so hearing from community members, as was emphasized in the morning presentation, trust is a central element of feeling safe and for our communities to feel safe. And so I guess that turned into a comment more than a question, but my question to the board is, what can we continue to talk about other ideas in addition to thinking about the reports themselves? Or are there activities or things that we engage in en route to a report?
Yeah, no, that's good point. You know, what I'm thinking of in terms of there may be more additional, you know, community forums that we put, or maybe in the area of the guidances, it's kind of thinking out loud right now, but thank you for raising that. I saw a hand by Board Member Smith.
Yes, thank you, Angela. I'd like to second the suggestion by Board Member Manju in regards to this year's report. I think those were some great ideas. And then also thinking about what Lily just offered up. I appreciate that too, in terms of thinking about different ways for community engagement and to hear from people that have been impacted by the very harmful immigration enforcement issues. I think last year around June or for the June meeting, or maybe the one right after that, we had a meeting with I guess what, 1 or 2 panels when we're talking about youth justice issues, right? And we heard directly from youth that had been harmed by police in schools or school to prison pipeline type policies and practices. So having that as a frame of reference, what I could envision, if it makes sense to do so, something similar as we move into next year, where we hear directly from maybe people. Oh, I don't know. I mean, there's also concerns for those people to want to come up and actually share their story, given the sensitivity of this issue. But so they probably have to think through a little bit more. And this is kind of an imperfect thought, but I'm thinking just something in the realm of hearing directly from more folks on the ground that are being impacted, or to the extent that their personal interests could be meaningfully accounted for, something along that line of thought. But yeah.
Thank you. And from my perspective, I think that all these are really, really good ideas to pursue. And I think from my perspective, it doesn't sound like anybody feels like we would need to make these decisions today. We'll be meeting next week as a board again. And some of these issues may be more in the realm of like looking forward to the following year and the issues that we want to focus on. And that will give us some time to reflect on what we have learned and talked about today. And then, as we are continuing as a board, both as a full board and subcommittees, the issue that was raised about other things we can do in addition to the report, so the community engagement, and there may be some steps in addition, like I had mentioned with the guidances, that we can do before the finalizing the next year's report. So I think these conversations from my perspective are just going to be continuing and definitely be part of next week's meeting, in particular, Manju, with, what information do we want to include in this year's report, and some of, the important, the slides, the presentations, information received today, to what extent and how we are going to include it, could very well be something that we could think about more and talk about next week, because we are going to be talking about the structure of the report. So, I think these are all really important issues that we're raising, and if others between now and next week have additional thoughts about it, I think that'll be another opportunity to raise those. Let's see, I don't see any other hands raised.
I'm going to jump in.
Oh,
Angela?
great. Yes, and who is this? Let me see.
This is Board Member Vieta.
Oh, yes. Great.
Yeah.
Hi there.
And again, appreciate the conversation. Thank you to everybody who shared. I think we all share similar sentiments and how we feel about this issue. Obviously, thank you to the presenters today. Thank you to the TOJ working behind the scenes to make it happen. Yeah, and I'm just gonna go kind of point by point because I was waiting to kind of condense it all to give you guys one comment here at the end. Yeah, and listening to that first presentation, I think I really appreciated, the law enforcement perspective on like the duty to intervene, especially like that responsibility as it's understood internally and like the tools they have, right, at their discretion, but also giving us perspective on, what's seen operationally and how it can be misinterpreted by the public. But I also think that that's like a really important context, right? Because the perception isn't just an image problem; it's like an inherently deep-rooted trust issue, right, between our communities and law enforcement agencies. So, when local law enforcement officers respond to like federal operations, and even if it's only to do, crowd control, right, as the example that was given earlier, I think that nuance, like it often doesn't really translate, right? Communities don't see it as coordination; they see that as direct alignment with, people coming into our communities to commit harm onto us, right? So I feel like that's where that's a slippery slope. But also hearing, DOJ presentation on SB 54, I kind of kept coming back to like how structure can drive behavior, right? We have like federal partnerships, these shared databases, and obviously like joint funding streams that have kind of built habits that are hard to untangle, right? And I don't think it's always an intentional thing. I believe it can be an institutional thing, or it is an institutional, I guess, problem or dilemma there. But like when those systems kind of start to guide how local agencies act more than California law does, I think that's when like the safeguards of SB 54, like what they were meant to create as safeguards, that's when they start to weaken, right? And I think that's where, it kind of, civil rights like problems and issues, kind of the exposure starts to kind of grow there, right? And not just like in the policy, but like really in public trust. And obviously, like DHS put us on notice last month. The AG made it clear, right, that ICE detainers are voluntary; they're not binding. Obviously, assisting in civil immigration enforcement, can violate state law, and sometimes, and in some instances, it can violate the Constitution as well. But also, just hearing them now on the call, right, kind of speaking about expanding data collection and like understanding the scope and scale of racial identity profiling as it pertains to stops and seizures, to detentions and transfers. I think maybe that's a bridge that we should consider kind of building next as we look forward to next year. Because if we can begin to kind of track some of those patterns now as it pertains to like immigration, who's being stopped, who's being detained, and how those outcomes connect directly to race and identity, then we can start to kind of shape policy in real time, right? I know we have to probably vote on some of these things and make motions. I'm assuming we're doing that. Next call for the full board meeting, I'm not sure there. But I think coming back to like really the point I want to make is I think like the duty to intervene, right? And like what it really means in this moment, like not only stopping or stepping in when during like acts of excessive force, but like recognizing when some of these power structures and these practices are, quietly producing inequity within our communities, right? And I feel like it's important for us to have clarity, not only for officers and for agencies, but like for our communities, right? Because we rely on them to protect and serve us. So maybe, next steps for us, I'm not sure what that looks like. Maybe we can consider looking at like clear statewide guidance or guidelines on like the duty to intervene and how it applies in civil rights context, especially around like immigration enforcement, racial profiling, and pretextual stops, right? Because I feel like that's what we're talking about a little bit here. It's kind of reminiscent. I was having like deja vu on like Rand and the 4th and the 14th, and all those conversations we've had over the last several years. But I also want to, suggest how we can look at expanding our data collection to include like detentions and transfers tied to federal cooperation, to see if we can actually identify some of those patterns in the data. And I'm almost done here. And coming from me, I think this is a big one. Even kind of exploring how we can protect agencies and officers who follow state law from being penalized, right? When like those decisions conflict with federal priorities or funding. And I think for me, it's like not about like it's for me, it's like how do we prevent confusion moving forward, right? For law enforcement agencies and officers. But for me, it's also like ensuring that like California's promise to protect civil rights doesn't depend on, you know, which badge shows up first, right? Or whose funding might be on the line. And I think, you know, that's how we move from like the technical compliance to like more moral clarity on how we address these problems in real time on the ground, because it is, you know, communities of color being impacted. It's innocent bystanders being kidnapped off our streets. And I think like as a board, we were created to kind of hold that line. So, you know, I'm open to hearing from DOJ or anybody else here on this call on how we can maybe expand on those points. But yeah, thank you all for allowing space for me to speak.
Thank you. Thank you. I think I saw a hand by Councilmember Kazi. Was that a?
Yeah, just to follow up on that. Thank you, Board Member Vieta. Like, I think you encapsulated a lot there that I was ruminating on as well. And I would really like guidance from our co-chairs of, you know, what this body is empowered to do. You know, I'm more familiar with the report and the recommendations. And so a couple ideas have come up, like Board Member Smith mentioned, and maybe a session where we invite kind of like a virtual town hall in terms of addressing and investigating more the policy gaps, the data gaps, and some of the novel commingling between law enforcement and federal immigration enforcement that we're starting to see, such as information sharing and dealing with demonstrators and protesters. If we cannot mandate anything here through this call, is it possible we do and we authorize our co-chairs to perhaps do a letter summarizing the points and concerns, and who would send it to, you know, the appropriate bodies who have the authority to kind of look into investigate that a little bit more.
Andrea, do you want to have any thoughts regarding that?
Sure. So, you know, River Board is a state body, and we are empowered to analyze the RIPA data, make recommendations on it, and off of it as it pertains to the elimination of bias and all the ways that happens. I think our community of immigrants and the extended community, because quite frankly, California is an immigrant state. You either are one, or you're related to one, or you work with one, or you live next to one. That we are directly affected by what's going on. So I think the racial identity profiling piece of this is really important. And as we know from our prior reports, you know, profiling is like the first step in what then becomes other violations, search and seizure, excessive force, right? So it's a continuum of activity. I think the most important thing we can be doing is elevating what's going on and working to identify what our own data tells us, to the extent that there's something within our mandate that we could add to the data collection through the regulatory process. We should try to do that. I think, you know, and then also the policy gaps, right? I think the landscape is changing so fast right now that it would be prudent for us to, for this year's report, reflect this conversation, which has been, in my view, like a really rich, incredible conversation, reflect the conversation into the report, and then really make space for these conversations in the coming year. Just because we, you know, the finalization of the report is around the corner. That doesn't prevent us from scheduling into next year extra sessions community hearings, forums, all the things that you all have been suggesting, I think is always a possibility. We don't have to wait till one more year's report to be elevating these issues. We don't have to wait one more full year to provide a letter, to send a letter. Like Angela and I have, or the co-chairs of the RIPA board have sent letters in the past to various bodies. That's also a possibility. So I think it's time for us to get really, really creative going into the coming year and recognize that, you know, where we are in the life cycle of the report and the capacity of DOJ right now. I think we'll talk about this next week, but I think the most prudent thing we can do right now is reflect the conversation and elevate the conversation in the report, and then put on our thinking caps to really go into 2026 strong, right? And really get a better sense of what we can do. Yeah, those are my thoughts, Angela. I don't know if you have any additional thoughts.
Yeah, no, I agree with that 100%. And I do feel that what we've done today as a board and our wonderful presenters, and by including this information in next year's report, if that's, I think we could continue that conversation as we talk about the whole report next week, but that does a lot to begin elevating this issue further. And so I think that is not at all to be diminished. I think that would be very important. And I think we're really getting, you know, we're at a good point right now to do some really great work in the coming year on this issue. As you mentioned, on, you know, what is a very changing landscape that we're facing in California and really throughout the country. So those are my thoughts. Let's see, I don't see any other hands. Any more comments from our board members? Oh, yes. Okay, Board Member Kajabi.
Can I just ask, I appreciate some of the comments in the chat, and Board Member Guerrero, you mentioned the Truth Act, and I don't know if off the fly you could say a little bit, or on the fly, a little bit more about that.
Yes, so I mentioned the Truth Act in my presentation.
I know you did, but I just,
yeah, that's okay.
Sorry. I'm wondering,
it was a lot of information. It was going really quickly.
Sorry to reiterate a little bit, because because I just want to circle back, because Attorney General mentioned, like, explicitly the idea of data and what this board could do, and so I just wondered if we could circle back. Yeah, thank you.
Yeah, so the Truth Act, it's not data that's collected through RIPA. It's data collected through a different process. But we do have, and we have a lot of data in California, both within and outside of the RIPA process, which is, you know, we know a lot about what's happening right now. So the Truth Act requires state and local law enforcement agencies to make public transfers, make public their joint task forces, which are, you know, really important to us because they are the exemptions under the California Values Act. And so how that plays out is at the local level, at least here in San Diego County, every year the county supervisors host a Truth Act forum in which law enforcement presents their data to the public, and the public responds to it. And in the county, that has led to the county supervisors adopting ordinances that that strengthen the state level laws. So we go one step further than the state level laws on a number of things because we're acting on that data, right? So the data is actionable if people choose to act. And the information that RIPA board collects and provides is all actionable. And so we're not the body that takes the action. That's not our mandate. But we are the body that elevates the information so that others, whether those are community members or local policymakers or law enforcement officials, can take the action. And, you know, I think like the data dashboard that like that, you know, we have a lot more work to do to make the information we're providing actionable because one giant report at the end of the year is helpful, but it's the amount of data is, it's 5 million data points, right? How does a local agency and local community members digest that and act on it? So lots for us to do, lots for us to think about. I think if we can reflect the richness of this conversation in the report, and then noodle on the things that we can do going forward. But I love seeing everybody actively thinking about this question.
Agreed. Let's see, I don't see any more hands up from our board members. And okay, so I think now is actually a good time to move to our second public comment agenda item. So let me open it up for public comment, and this time I'll start with Northern California. If anybody from Northern California would like to make a public comment, if you could raise your hand, and then I will be able to see that and call on you. Not seeing any. I will move to Central California. If there are any members of the public who would like to make a public comment? Okay, not seeing any. I will move to Southern California to see and ask if there's any members of the public who would like to make a comment. Okay, I don't see any. So with that, we can move to agenda item number 4, which is summary of next steps and vote on any action items. And, from what I'm hearing as kind of a general thoughts and consensus generally from our board, and I do really want to thank everybody for this high level of engagement, really appreciate it, that again, with the perspective, we're meeting again next week to talk about the report, and that will include kind of visions for next year, that we're going to reflect as a board on this really, these rich presentations and information that we discussed today, which is including both, the current state of California law, the issues of a duty to intervene, the issues of data collection and potential gaps, both to look at the current data that we may have going forward, and potential gaps in data that may be helpful for us to consider, as well as, thoughts about further thinking about what we want to include in this year's report with respect to what we've learned and how much of that to include. Also thinking about ways that actions that we can be taking in further engagement, in the next 12 months, the next year, that isn't solely about what will be included in the report, but other actions we may want to consider taking, including other community forums, or other guidances that we may want to weigh in on, partner with other agencies, or produce something for us to consider. So, anything that we can do, to elevate this, help fill in gaps, and be impactful as a board, ultimately, serving our mission, which is to, as we all know, to help eliminate racial identity profiling, and decreasing bias in law enforcement interactions. So with that, again, I want to thank all our panel members. I want to thank the Attorney General for his time. And with that, I think that we will be adjourning, and I will look forward to seeing everybody, and look forward to our conversation next week. Thank you all, and thank you all for our members of the public who have watched and who have engaged with us. And thank you for Department of Justice staff who put together this really important and helpful meeting for us and for the public. Thank you so much. So with all that, I hope everybody takes care, and I'll see you next week. Thank you.
Thank you.